Right, good morning, everybody. Welcome back. I hope you had a good weekend. It's 10 o'clock and the inquiry has been resumed. Could everyone switch their mobile phones to silent, please? I'm resuming the inquiry into the appeal made by BW Homes Northampton under Section 78 of the Town and Country Planning Act 1990 against the refusal of Fenland District Council to grant permission for a planning application comprising the erection of up to 200 dwellings, including affordable housing, self-built custom dwellings, 2.3 hectares of safeguarded land for primary education, public open space, landscaping, children's play area, sustainable drainage infrastructure, the formation of 2 vehicular accesses, and all other associated infrastructure. And that's an outline application with matters committed in respect of access. Everything else is a reserved matter at land east of 61 March Road, Coates. This is the 6th day of an 8-day inquiry. Welcome to all of you who are, well, any of you who are watching on YouTube. This week, we are dealing with the outstanding matters of the 5-year housing land supply and town planning related matters. Last week, we dealt with viability and education, and the week prior to that, we did the site visit and landscape issues. The schedule for this week will be starting at 10 o'clock every morning. We will be dealing with the 5-year housing land supply this morning. On the conclusion of that, we'll start our town planning evidence from the council, and tomorrow is reserved for the conclusion of the town planning evidence with the closing submissions on Thursday morning. Okay, before we start, there's no one wishing to speak today, okay? I've received a number of documents, and I think from this point forward, we'll record all documents as ID documents instead of updated documents, just so that we know where we're at and where to find things. So the ones I have, we're up to ID 12. Okay, so the first one is the appellant's NPPF landscape. Landscape. I've made terrible notes here, just bear with me for a moment. Mr. Smith's note in relation to landscape, visual and character matters is ID 12. ID 13 is the appellant's NPPF planning update, dated 21st of the 8th. ID, have you got that, Mr.?
So yes, I'm making a note as we go through. Thank you.
Yeah, yes. ID 14 is Mr. Lee's updated NPPF proof of evidence from the council. ID 15 is the same from Mr. Davey. And ID 16 is the appellant's note on 5-year housing land supply NPPF. And for the absence of doubt, that's the one that starts with the letters R009 version 1. Okay, I've also received some costs information in connection with the application by the appellant, and I shall be allocating those their own numbers as opposed to ID numbers. So the application is costs 01, and there's 3 appendices with that. And that would be a good point, I think, to pass over to you, Mr. Boyle.
So thank you very much. Thank you for that. So yes, the cost application sent through to the council as promised yesterday. The way I've drafted it is, you'll see when you come to read it, there's a substantive claim for a full award of costs, the basis of the council's case. There's then, in the alternative, a partial award being sought on conduct basis, and there are 3 heads of that: viability, land supply, and Section 106 matters. And that's what informs the 3 schedules, or 3 appendices, that sit behind the application. Within the schedules, as you will look at them, you'll see that it's done on a sort of chronological basis, and the evidence, whether it's a document or an email or something, is then on a hyperlink click. And because certainly I find it incredibly tiresome to have to go and click all the documents, we have provided you with half a tree just there. So I hope that's helpful. If it's not, just bin it, but I hope it's helpful. In any event, you've got a hard copy of the application and the schedule sitting on top. And then we've copied you the documents which you would otherwise have to go off and search for the link.
Okay, that's why I bring a tote to inquiries for matters such as that. Could I ask the council how they're doing on their costs application if they intend to submit a written rebuttal?
Yes, sir. I mean, I was intending to submit a written rebuttal as an appendix to my closings. So obviously there's a large number of appendices, etc., but the substantive application that I need to deal with is set out very helpfully by my own friend, and I received that yesterday. So that's my anticipation. If anything should change over the next day or two in the evening time as one is drafted, I'll be sure to let you know. But that's certainly my anticipation. I can deal with that as an appendix to my closings. I think my own friend intends to reply orally to that response.
Thank you very much. Returning then to the IDs, the inquiry documents, the list that I've just appended, are there any additional documents or any comments on the ones that we've taken in?
So I think the only additional document, as a matter of formality, is the Housing Land Supply Roundtable agenda, which was travelling between the parties, and I think received your imprimatur.
Yes, let's take that in as ID 17 then. And thank you, Mr. Pritchard, for sending that through yesterday. Has the council had the chance to see the Housing Land Supply agenda? Great, thank you. Any comment? Thank you. Okay, any other housekeeping matters?
So the only matter in terms of planning, I had the opportunity to word with my own friend this morning, is obviously you'll have seen Mr. Davies' planning evidence dealt with two principal points. The first was the question of 5-year housing land supply. The second was the question of what was the reverse presumption of paragraph 14 of the old NPPF, which has been carried through in a different way to the new NPPF. Given that Mr. Davies' evidence with respect to 5-year housing land supply will be dealt with in the round table, and given the position that he pragmatically sets out in his addendum with respect to new NPPF and the presumption with respect to neighbourhood plan, I don't anticipate that there's any need to call him as a planning witness this afternoon, given the neighbourhood plan point has been resolved and 5-year housing land supply will be dealt with in the round table this morning. So I'm certainly not intending to call him again as a separate planning witness. I don't think that would be a sensible use of inquiry time.
Thank you. Anything from the appellant?
So yes, my friend did mention this to me this morning, and we respectfully agree. I mean, I have to say that we didn't find Mr. Davies' update particularly pellucid in its conclusions, but it has been clarified to me that he means to drop the NPPF neighbourhood plan point. So it's now S6, it was paragraph 14. And on that basis, there's no need for him to be separately called this afternoon planning evidence. I accept that. We will have to deal with what appears to still be his case, that windfalls are permissible under the new NPPF. But that's agenda item 5 on the round table, so we'll cover that there. And I'll be making a contribution to that part of the debate.
Thank you. Okay, then turning to the 5-year housing land supply roundtable session. I did say last week that I was a little concerned that I wouldn't have sufficient time to read the evidence as thoroughly as I normally would before a roundtable session. That has been the case. So this is going to be a slightly different format today. I've obviously got a base knowledge on which I've gained from reading the evidence on a sort of first run-through basis. But I will be looking to the parties to take me through their evidence rather than asking questions from myself as intensively as I might have otherwise. We will follow the agenda sent through by Mr. Pritchard yesterday on ID 17, and I expect that we will also, well, we definitely will also be looking at the notes that have been sent through, which include, sorry, I don't have CD numbers for these, as I've just filed them as in their raw state, but we have the final updated housing need and supply statement of common ground. We of course have the new NPPF and the PPG on viability. We have the appellants R003 version 2 updated housing proof. We also have the appellant's R009 version 1 note on revised NPPF, which is ID 16. We have Mr. Davies' proof of evidence on the 5-year housing land supply. And there is also the disputed Appendix 1 consent since April the 1st. Now, you might have seen the note from me that I sent through at the end of last week saying that I didn't dare open that one. So when we come to the status of the sites, then the parties can take me through what they see as the most important sites. Although I do realise that in this case, it all turns on the head of a very small pin in terms of numbers and what the 5-year housing land supply is or could be. So the important sites may be a long list. Good. Is there anything else that I should have open?
No, that's all.
Ah, yes. Thank you. That's right. I was only going to refer to that in the windfall section, so just as a definition point. Okay, let's open the agenda. So the first point on the agenda is the consistency of the policies of the local plan with the NPPF insofar as the provision of housing is concerned. And I'll ask the council to open on this as it's their local plan, referring to the neighbourhood plan as well if necessary. And with reference to the new NPPF as well, what is the consistency of the policies in your view? Hello there. Sorry, could you introduce yourself?
Yes, I will. Can I just check that everyone can hear me? Fine. Okay. Yes, that's fine. Yeah, I'm Robert Davey. I'm the Planning Strategy and Specialist Services Manager for Fenland. So I think the position is set out in the proofs in that respect. Although the proofs were provided at a time where the NPPF 2024 had full weighting and was therefore national policy, we do recognise that the figure of 447 was below the 550, which was the target set under the old East of England plan. And we've acknowledged that that effectively has been superseded by standard method in line with national policy, which was the case under the 2024 and the iteration that was published last week. Sorry. Okay. Yeah, that's fine. So just to, I'll just repeat that point. We recognise that 447, which was the average delivery between 2011 and 2026, I think the average was referred to in the proof, is below 550, and that was the housing target that was established in the 2014 district plan. We recognise that the national policy position has moved on since that point, and we now are required to hit 602 per year. But we also clarified in the proof that the plan period is ongoing. It's not expired.
Sorry, could you repeat the last point you just made?
The plan period and housing delivery is still ongoing, so it's not concluded as yet. And we've also referred to the housing delivery test The results in the proof were 2018 to 2023. They enabled the council to achieve an average delivery score of 96% across those 6 periods. So they varied between 92 and 98, I think, was achieved 1 year. Now, also in my addendum, I noted alongside the publication of the 2026 NPPF, the release of the 24 and 25 HDT results, and Fenland achieved 100% in 2024 and 117% in 2025. So that really backs up the earlier assertion that housing delivery is ongoing. And obviously, the issue of windfall is quite significant in terms of this borough, but it does seem to indicate that you cannot hit scores that this district achieves without having an ongoing source of supply via the delivery in locations which are not identified in your local plan.
Thank you. There's a few issues there we'll return to in subsequent sections of this morning. Does the council have a response? Hello, could you start by introducing yourself?
Certainly, sir. Neil Tiley, Senior Director of Pegasus Group. Mr. Davey has covered agenda items 1 and 2. He's both covered the record of delivery relative to the requirement, as well as the consistency of the requirement with the need. I'll focus just on agenda point 1 for now, and then return to agenda point 2, sir. So we are agreed in paragraph 2.5 of the Statement of Common Ground, and I'll read it for ease, sir, that the policies of the adopted local plan provide for fewer homes than are needed as a minimum according to current national policy. And that obviously flows from what Mr. Davey has just said. As if we then turn to the framework, sir, and paragraph 16 of the introduction, it sets out that at a very high level, the objective of sustainable development can be summarised as meeting the needs of the present without compromising the ability of future generations to meet their own needs. We are agreed that the policies here do not meet the needs of the present and do not meet the needs of future generations, such that the policies of the development plan here do not provide for sustainable development as defined by paragraph 16 of the framework. Similarly, if we turn to paragraph 17, sir, it identifies that sustainable development has 3 objectives, which are to be pursued in mutually supportive ways. The second of those, under B, the social objective, requires that we ensure that a sufficient number and range of homes can be provided to meet the needs of present and future generations. We are agreed the plan here does not do that because it doesn't meet needs, and therefore the plan does not provide for sustainable development as defined by paragraph 17 of the framework.
And both of these paragraphs are carried over from the old NPPF.
They are, yes. And obviously, sir, the primary purpose of the planning system is to contribute to the achievement of sustainable development. We have policies here which do not do so, sir. Indeed, sir, insofar as the provision of housing is concerned, the policies are materially inconsistent with the framework and the presumption in favour. Sorry, not the presumption in favour, and in achieving sustainable development.
Now, is that primarily a function of the housing land supply, in your view, being out of date or being under?
No. It's that the policies, in fact, if we turn to the local plan, paragraph 1.1.3, you will see that the local plan is aiming to deliver 11,000 new homes over the plan period. That's 550 homes per annum. So the policies have been designed to aim to deliver 550 homes per annum. There is now a minimum need for circa 602 homes per annum. So the policies themselves were never designed to provide for housing needs as defined by the current framework, and therefore do not provide for sustainable development as defined by the current framework. The consequence, well, sir, I would suggest that fact alone will be material to the weight one affords to the policies and a conflict of those policies.
Mr. Daly, in your view, thank you. In your view, what Mr. Harvey said had an impact on council's assessment? Say that again. In your view, what Mr. Harvey said, does that change anything that you've said to me so far?
I think, as you asked, as you referred to in your question, sir, paragraph 17, fully aware of what it says, it's carried over from paragraph 8 to the previous framework, but there is an economic objective, a social objective, and an environmental objective to sustainable development. So that should be noted. It's not just a question of housing by itself.
So can I just also come back on a point? I think there's a discrepancy with the first point, is that the council was not accepting the policies don't meet the needs. There is an aspiration in the local plan to provide a certain number of minimum houses. The policies of its time, but the policy was a floor, not ceiling. You know, and as Mr. Davies said, you know, just look at the last 2 years, 100 and 117% of housing delivery in a plan that is, over the passage of time, older, but I think is evidenced clearly not out of date. If the policies were not able to meet the housing of today, we would not be hitting the housing delivery targets of today, and that is a simple numerical fact, I would suggest. You know, arguing any difference, you know, the three strands, economic, social, environmental, tied in from the MPPF in 2012, you know, that core golden thread predates this local plan. To try and use the fact that it's in a document that was released last week undermines our current plan is, I don't think, has any merit. But yeah, I think you just need to look at the level of housing delivered to confirm that plans aren't, policies aren't out of date. It's not just a passage of time. You look to actually see how they've achieved what they've achieved and how they've delivered.
Firstly, paragraph 17 requires that the objectives are pursued in mutually supportive ways. It doesn't say that you shouldn't meet housing needs to provide for environmental protection. You've got to achieve each of the objectives. So that point goes nowhere, raised by Mr. Davey. Secondly, Mr. Lee said that they don't agree that the policies provide for fewer homes than are needed. That's resulting from the clear words in paragraph 2.5 of the Statement of Common Ground, sir. And as I'm sure you're aware, that will constitute unreasonable behaviour. The third point is Mr. Lee said that the housing requirement was set as a minimum within the local plan. If Mr. Lee turns the local plan, that's not the case. It was a target. It wasn't a minimum. The local plan doesn't identify that it's a minimum anywhere. Fourthly, sir, Mr. Lee relied upon the housing delivery test results as suggesting that this council was exceeding need. However, Mr. Lee fails to recognise that, as set out in my proof of evidence, the housing delivery test results are measured against the former standard method, not the current standard method, so they don't provide any measure as to whether current needs are being met, and not against the housing requirement, so they don't provide any measure as to whether the housing requirement is being met.
Can I ask you to pause there? Just a quick question on that. What would have the requirement under the previous standard method been?
It varied from year to year, but it was 530 on average across the 3-year period in the 2022 to 20.
Sorry, Mr. Tiley, that's incorrect. In 2025, the standard method was 593.
It's gone up by 9 houses.
To 602, thank you.
That's the context, I think.
So we can provide evidence on this if you would like the housing delivery test results provided to you. The most recent ones are measured against the former standard method, and it's set out in the technical note that accompanies them. So we can submit that as a publicly available document, which will confirm that the council is wrong on that matter, sir.
Thank you, Mr. Tiley. And your fifth point?
And the fifth point is Mr. Lee said that or appeared to suggest that the need had changed in the last week. That's not the case. The standard method has remained consistent since 2018, sir.
So just to clarify, the calculation for the standard method last year required 593. It's not 530.
I've got 593 and 602 currently. Thank you. Thank you. Yes, Mr. Lee.
For clarity, I don't think anything I said is in conflict with what's in the Statement of Common Ground. The Statement of Common Ground accepts that 447 was what is in the plan, or was delivered, or so was an average, and this is lower than the 550, etc. What I'm saying is that the policy has delivered housing that is what is needed. It's not saying that anything's not conflicting with anything like that. The policy has delivered, and while the local plan does not explicitly say this is a cap or a specific figure, the planning system allows for sustainable development. It allows for windfall development. It allows for delivery above and beyond those figures. This is basic parts of planning. This is to try and turn an argument on small semantics seems flawed. These are key aspects of planning, I would suggest, rather than trying to look to specific wordings and trying to turn when I can't agree that I've said anything that disagrees with anything in the Statement of Common Ground. Thanks.
I think also the fact that the economic, social and environmental are interdependent, we fully recognise that. We aren't looking to advance an argument about using housing or a lack of housing delivery to ensure environmental protection. We're not Castle Point Council, for example.
2 brief points, sir. In respect of Mr. Lee's point on the Statement of Common Ground, the wording is clear. The policies of the local plan provide for fewer homes than are needed as a minimum according to national policy. And the explanation for that is provided in the preceding 2 paragraphs, which identifies that the plan provides for 550 homes per annum and there's a need for 602 homes per annum. In terms of the housing delivery test, and as I say, we'll perhaps provide the data to you in the technical note. What the council have done, they've identified that the former standard method identified the current standard method needs for 593 homes per annum last year. The housing delivery test identified that 593 homes were delivered in 23-24. It sets that against a need for 527 homes, i.e. that which arose from the former standard method. So they've confused the supply with the requirement within the HDT, sir.
Thank you. I want to return to the housing delivery test in section 3 of the agenda. Before we do, though, we'll just move on to section 2, which is the vision of the local plan. And I'll ask the appellant to start on this one, please. I think we've touched on it already.
The council certainly have, sir. Now, we're agreed in the Statement of Common Ground that the plan aims to provide fewer homes than are currently needed, and that's just an indisputable fact, sir. But against that housing requirement, sir, we can see from figure that insufficient housing requirement, we can see from figure 6.1 of my proof of evidence, sir, which I'll turn up one moment. Figure 6.1, it's on PDF page 28, sir. PDF page 28. We can see that across the plan period, there has been a significant shortfall, even against that insufficient housing requirement. Indeed, across the plan period to date, there's been a shortfall of 1,540 homes relative to the insufficient housing requirement. And that shortfall has existed. So the plan was adopted in 2014. So over the period 2014 to 2019, you can see the shortfall increased because there wasn't sufficient supply to meet the requirement over 5 years from the point of adoption. Similarly, over the period 2014 to 2024, you can see the shortfall increased because there wasn't sufficient supply to meet the insufficient housing requirement over the first 10 years from adoption. So the plan would not now be found sound because it wouldn't comply with policy H03 of the new framework, sir. So not only has there been a significant record of shortfall against the insufficient housing requirement to date, we agreed in the Statement of Common Ground in paragraph 2.9, sir, that even if the supply of the LPA was achieved over the next 5 years, which covers the end of the plan period, a total of 10,411 homes would be delivered in response to the requirement for 11,000, sir. So even if the unrealistic, well, in my view, unrealistic supply of the LPA was achieved, the policies of the plan would fall significantly short of meeting the insufficient housing requirement of the local plan over the plan period. Now, sir, by any reference, the policies in this plan were aiming too low and have failed to meet even that insufficient target. And that will clearly be material to the weight accorded to those policies. Thank you, sir.
Could I just ask the council to pause before its response, because my computer's done a spontaneous restart, so I just need to. It's a few years old, aren't we all? So just bear with me for a moment. Apologies. It doesn't like having too many PDF documents open at once, so I think we're due for new ones. Apologies. Oh, good. Right, it's restored everything that I had open, so that made things a little bit quicker. Okay, thank you. The council, please. Would it help if I asked you a direct question?
Yes, sir.
Did you have anything to respond to that came to mind from Mr. Tiley's? And then I can move on.
I think I did cover some of those points in my opening statement, sir, actually. We do acknowledge that delivery of 447 on average is below the target. We do recognise that the changes that the standard method has then introduced, and we do calculate our land supply position based on standard method, which is in line with the PPG. We do recognise that the policies were drafted and adopted over 10 years ago. Yes, we do need to, as you'll appreciate, and the appellant will also appreciate, we do of course have exercises to do to appraise everything within that local plan against the new NPPF in detail, which again will be part of the work for our new style local plan. We don't have all that to hand at this time.
Thank you. Okay. Anything else on agenda item number 2?
Can I just draw the threads together, if I may, because as you appreciate, these roundtable sessions are difficult to pin final positions down. But you've just heard, great respect, Mr. Davey, him acknowledge in terms that the figures derived are below the target sought, and the target sought is below the standard method need. And saying, well, I recognise the policies drafted and adopted in a different regime, the necessary consequence of that is acknowledgement of inconsistency with the NPPF. And to my mind, all you need to look at is paragraph 2.5 of the Statement of Common Ground, matters not in dispute. Fewer homes are planned for than the minimum needed, and 2.9 and 2.10 Statement of Common Ground, even assuming the authority's planned delivery, expected delivery, forgive me, it'll be 10,411 against 11,000, 11,000 being already recognised to be an inconsistently low figure. So the authority has to face up in terms of consistency point to the acknowledged facts which have just been put out. And the use of sort of loose language like we acknowledge or we need to recognise. No, you need to be very, really clear here. The plan, and it shouldn't be controversial actually, the plan wasn't designed to meet the numbers which the government says is now needed. It hasn't even met its own numbers, and therefore the plan is inconsistent. It's inconsistent with the MPPF, it's inconsistent with its own vision. And that needs to be pinned down and recorded as a point.
Thank you.
But again, the counterweight to that, sir, with great respect to Mr. Boyle, is that the planned period is not over. Housing delivery is still ongoing.
No, but
There
that
are some
doesn't.
of the allocations that have not yet been built
Forgive me,
out.
that takes no one anywhere because 2.10 of the agreed statement of common ground is assuming the authority's ongoing delivery up to the end of the planned period. Look at 2.9. And even then it's only 10,411 against 11,000. But the point is 11,000 isn't what's required. It's more than that that's required. So that's why I say it's really, really important, because we have to make submissions here often in terms of how we operate the MPPF and its policies, to have it established that the Council has recognised through the agreed facts that the plan in respect of housing is not consistent with the MPPF. It can't go anywhere else.
Don't agree with that.
Could I ask you to refer to paras 2.5 and 2.10 of the Statement of Common Ground?
Yeah, obviously. So Paras 2.5, the policy of the adopted local plan therefore provide fewer homes than are needed as a minimum according to the current national policy. No one disagrees with the figures that were set are lower than the national policy. However, that doesn't automatically mean they're out of date, because you have to look at their conformity and what they've delivered or not delivered. Taking into account the fact that the majority of the council's allocated sites haven't been built out yet, means that, it's likely that the delivery will continue. If you look 100%, 117, 90, there appears to be an increase. I think the new MPPF to some extent acknowledges that the beginning of the local plan is likely to deliver fewer houses because it provides an 80% target for your 5-year land supply for the newly adopted local plan. So the government acknowledged that at the beginning there will be a slower delivery rate than as the plan comes through. So to have used a figure that says if we carry on as an average, we will not meet it it's an arbitrary figure. It doesn't evidence the increase that's coming. The fact it'd be a very different conversation if we're in another authority where the allocated sites have been built out. You would be going, where are these houses going to come from? We're an authority where the allocated sites have not been built out. It is a natural and fair assumption to see if some of them will come forward, and they will provide a much bigger delivery of housing numbers than has been provided in theory through windfall sites over the last 10 years or so. And that's the big difference. And I think I'll be honest, I think we're probably going to go around in circles saying either side disagree with this.
We've got to be really strict here, so forgive me. That was just noise from Mr. Lee, I'm afraid. The figures are in the document you asked him to look at. The prediction of the authority is a further supply of 3,710 added to the completions of 6,710. It undershoots its own target of 11,000. We can't have this sort of popping up from behind the parapet and giving a different spin. The Statement of Common Ground establishes that the authority themselves are expecting to undershoot a target, which the authority themselves have accepted is inconsistent with the current requirement. Simple as that.
I can pick up three.
Yes.
Mr. Lee said that it doesn't matter that the policies we're aiming too low. One needs to take account of what's been delivered and what will be delivered. We've been through, sir, that there's been a significant record of under-delivery relative to the adopted housing requirement, which were agreed is insufficient. And were agreed that even if the supply identified by the LPA, which I consider is unrealistic, is delivered, there will remain a significant shortfall against the insufficient housing requirement. So the evidence is quite clear that even if you were to adopt Mr. Lee's approach, the local plan would be inconsistent with the framework. The second point, sir, is that Mr. Lee said that you only need to demonstrate 80% of a 5-year land supply in a recently adopted plan according to the new MPPF. That's not in the new MPPF as far as I'm aware, sir, and if Mr. Lee could assist with that, that would be useful. Thirdly, Mr. Lee said we've got allocated sites that will come forward. Those are already accounted for in the supply of the LPA, and therefore they're already included in the evidence we've provided, sir. Thank you.
Okay, thank you. We'll come back to a few things there. Can I ask the council, Mr. Davey, you identify several appeal decisions which might be relevant. Is there anything that you want to point out specifically in relation to this issue?
I think on that point, yes, we have had some updates on the deliverability and likely timeframes of those appeal sites. If you can just bear with me a second, sir. I'll open that up.
Is there anything specific with regard to shortfall and delivery that you want to raise? Flag with me.
We would be. I think we may be transgressing over onto item 5. If I do that now, I can do that, or we can hold off slightly. But in respect of the site allocations, and again,
No, I'm asking more in the round. So, has an inspector, for example, previously found that the shortfall is acceptable against the housing delivery test?
that hasn't really been the case.
Sorry.
That hasn't really been the case in this
Okay.
authority. We referred to the appeal at Doddington in June, where although that was based on the 2025 to 2030 schedule, and that's, I think the figure was 6.60 years. It was slightly before I joined the council, but that inspector was satisfied as to the robustness of the housing land supply position now. Mr. Tyree had referred to that in his evidence, and it is true that the detailed warts and all run through the schedule didn't take place at that time, but that particular appellant did look to advance an argument that the council had around 4 years' supply. There isn't a record of detailed inquiries into land supply position in this district. That's a good question.
Okay. Could I ask you about Mr. Tiley's figure 6.1, the one he pointed out on page 28, PDF page 28 of his proof? Which is the cumulative shortfall, and what I'm trying to establish here is, I trailed in my previous question, the importance of this versus the housing delivery target figures.
So, sir, could you confirm the document reference?
Yes, sorry. It's I believe it's a core document.
No, it's a proof of evidence.
It's housing proof. That's if you've got the raw document, it starts with R003 version 2.
That's paragraph 6.1.
Yes, figure 6.1, PDF page 28.
I think it might be CD 14.04, sir.
CD, that's very helpful, thank you.
Thanks, yeah. Just got that. Okay. I think again the text, the preceding few paragraphs just clarify that yes, there is that average of 447, which Mr. Tiley refers to in it's 6.6, paragraph 6.6, and subparagraph 1. That again is mentioned in the statement of common ground, and as we have said, yes, this is below the adopted requirement, but that housing delivery is still ongoing, and the plan period has not yet expired.
You seek to rely on the housing delivery test figures as you know, the high percentage rates. What importance do you give the data in figure 6.1?
Well, the housing delivery test is evidence of a delivery performance. Now, that of course does take account of active completions over a 3-year period. What we say in terms of the overall importance of that, and factoring in the two most recent editions, that gives an average of, if I remember rightly, I think it's 99.1% to a decimal place. So that would infer that cumulatively over the whole period, the target has more or less been met. It's only very slightly dipped below. Now, of course, there are year-on-year variances to that, and the fact that over the years of 23, 24, and 25, that 117%, of course, will amend the average. So yes, there is, of course, there is. I'm not saying this graph is incorrect at all. There is a below target delivery clearly indicated there, but 447 is the average over 15 years. That is below 550. But we have said that repeatedly, that the housing delivery is ongoing and our plan period is not yet over.
Thank you. Mr. Tully, could I ask you the same question?
Yep, certainly, sir. If we turn to figure 6.1, firstly, this is being measured against the adopted housing requirement. As I've said before, the housing delivery test is being measured against the local housing need of the former standard method. So they're comparing different things, but coincidentally, sir, you will see that over the last few years of figure 6.1, the shortfall has decreased. So there has been delivery in excess of the housing requirement and the former standard method over the last few years. But that hides the fact that over the plan period as a whole, over 5 years from the point of adoption, over 10 years from the point of adoption, and over the plan period to date, there will be a significant shortfall against the adopted housing requirement, which falls short of meeting current local housing needs. And that's the considerations that's material. In terms of the weight to be afforded to policies, that's got to be determined by the extent to which those policies meet needs. The HDT doesn't assess that because it's using the former standard method, but we know that the record of delivery has been significantly less than the housing requirement, which it underplays needs. And that's the factor that will be material to the weight afforded to policies, in my opinion, sir.
I think just as a further comment to that, Mr. Tyler has just identified that.
Sorry, just a moment, Mr. Davey. I just need to close this door because I can't hear that coffee express going in the background. Okay, sorry about that.
Yeah, Mr. Tyler has just identified correctly that the trend line is now moving upwards. It's again there's a lack of clarity over the definition of significant underdelivery, which has been alluded to already in some of the documents. As I've said, the plan period and housing delivery are ongoing. So again, this upward trend line, the indications are that it will continue. And that's if we were to ignore the publication of the 2026 NPPF for a moment, that would help to suggest that there are ongoing sources of supply in the guise of windfall sites, which we were challenged robustly on.
Again, so you're just hearing this repeated refrain. The plan period is ongoing, housing delivery is ongoing. The council have agreed the figures for the plan period ongoing and delivery ongoing. It's paragraph 2.9 and 2.10 statement of common ground. And it concludes that there's an insufficient supply on the council's case against the 11,000, and it's agreed the 11,000 is less than what is actually needed. So that repeating the refrain doesn't help anybody.
But the plan period is not over.
Forgive me, that's the point. 2.9, 2.10 are looking forward to the rest of the plan period on the council's figures, and it's less than the council planned to deliver. It's 10,411 against 11,000. The council's figures.
Right then, let's move on to the 5-year housing land supply requirement. Thank you. Thank you, Mr. Boyle and Mr. Tarley and Mr. Davey and Mr. Lee. We have as we've just already established in the proofs and this morning, we have a local plan need of 550 homes per annum from the 2014 local plan with a period going through to 2031. Current need is 602 based on the current standard method, and the historic supply is 447 per annum. So they're all correct, aren't they?
Subject to a minimal rounding within the standard method, yes.
Yes. Yeah, a bit difficult to build 0.4 of a house, but
Yeah.
okay. So I think to bottom this out, we're going to need to move on to the disputed sites. Is there anything that anyone wants to raise on agenda point 3?
No, sorry. On the 5-year requirement, so this is the requirement against which the 5-year land supply is to be measured. National policy Annex D, to the framework identifies that where plans are more than 5 years old, as is the case here, the 5-year land supply is to be calculated against the minimum local housing need of the current NPPF, with in this case, a 5% buffer, because the HDT results demonstrate there's not a significant record of under-delivery over the last 3-year period. We are agreed that the standard method identifies a minimum local housing need for 602.239 homes per annum, and that's set out in the council's evidence. If you times that by 5 to identify the 5-year, the need over 5 years, and add a 5% buffer, you come out with a requirement for 3,162 homes. The council, however, round that 602.239 down to 602, such they're applying a local housing need less than the minimum local housing need. They then calculate a 5% buffer and again round that down. And on that basis, they identify a housing requirement for 3,160. Now, the positions aren't materially different. It's only 2 dwellings served, but there is a circumstance in which that could be determined hypothetically.
Is it not a standard approach by councils to round it down at each stage?
No. In fact, the housing delivery test use unrounded figures. And in my experience, I've always used unrounded figures, because if you're rounding down below a minimum, which is clearly contrary to national policy.
Council, first of all, if you were to use the figures with decimal points, what difference would that make to your calculations?
It would account to 2 homes, as Mr. Tiley says, and but again, that would require the use of the 3 decimal places, which, yeah, you can argue that's the practicality of that really overall. And how would you build 0.239 of a home?
So the thing is, it's not 0.239 of a home, it's 2 homes, because you're doing it over 5 years with a buffer.
Is there anything else before we move on to disputed sites?
Just to record where you find those figures, helpfully, in the Statement of Common Ground on Land Supply, it's paragraph 3.8 for the appellant and 3.9 for the authority.
Can I just comment one thing on your rounding down point? My experience at previous authorities is that, you work out the amount of housing you need for the year, round it appropriately, and then multiply it by 5 rather than taking the figure multiplied by 5, then look to deliver it. That's just my experience from other authorities as well.
Yeah, so that has also been mine as well.
It's not my experience, sir, and I for my sins, I'm a maths graduate, and that's a fundamental error, mathematical error. You only round at the end of a calculation. If you round throughout a calculation, you end up with a rounding error, as we do in this case of 2 dwellings. It's fundamentally contrary to mathematical principles. It results in a requirement which is less than the minimum identified by national policy. Those are the two points.
You would round to the nearest whole number though, and 0.239.
You do at the end of the calculation, but not for each input.
Well, that sounds to that extent, doesn't it? The calculation is how many houses you need, then you times it by 5. It's not. So I would suggest that's what it's done. You work out the houses you need, you round that then to get the figure, and then in the process of it being extrapolated up to 5. I point where you're coming at, but the point is the original calculation is where you would do your mathematical correction, I would suggest. I'm only relying on my A-level maths then, I'm not a graduate. So
It's fundamentally wrong as a mathematical principle, sir, and as I say, it results in a figure below the minimum.
Like I said earlier in the inquiry, unless it comes in pictures, I'm going to take your word for it, both sides' word for it. I'll take those away. and reach of you. Thank you. Can I ask the appellant if it's had the sufficient opportunity to digest the council's Appendix 1?
Appendix 1. Let me see what Appendix 1 is. Oh, is that the schedule of sites appended to the Statement of Common Ground? Yes, we have, and I've responded to it within my note on the MPPF, sir.
We might call it the attempted Appendix 1, because it didn't ever form part of the Statement of Common Ground. So I think got its own ID number. But yes, you've seen the appendix at the back of Mr. Tiley's note that came in yesterday. But so you appreciate that schedule is not put forward by the authority as suggesting additional supply that you take into account for the numbers we're about to look at. That's another exercise, which they say relates to windfalls, which we'll come on to at the end.
Yeah, the disputed sites are set out in the Scott schedule attached to the Statement of Common Ground.
So the best place to refer to this from the next section then would be your proof of evidence.
No, the Scott schedule.
Sorry, completely ignored what you said there. Sorry about that. So that is Statement of Common Ground from page 14 onwards.
So are we now on item 4, so the agenda?
Yes.
Disputed sites. There's a helpful table in Mr. Tiley's note, table 1.1, which might give you the sort of headline figures. So if you see that table, now that's using the 3162 figure, which he says is correct. You could alternatively put in 3160 figure, which authority you'd like to round matters down to, and then you'll see the dispute of the supply, 3174 and 2101, and the role of windfall within that, and then the surplus and shortfall at the end.
Sorry, Mr. Boyle.
I'm so sorry.
The table, I'm just having trouble finding it in Mr. Tiley's proof.
No, it's in his note, sir.
Forgive
me, his note.
Right,
it's the second page in. It's under paragraph 6. It's table 1.1. And I'm just noting, for fairness to authority, that the top figure is 3162. It could be 3160, depending on the discussion you just had about maths. And then there's the rival supply figures and the role of windfall within that, and the surplus or otherwise. So if you have that as it were a sort of a headline position, and then in terms of the individual sites, which is what we're going to come to, as Mr. Tiley says, you need to go to the Statement of Common Ground Scott schedule, which is the appendix at the back, and rather unfortunately just literally have to go through the dispute one by one.
Sir, I can probably make it a bit easier for you in that the parties are agreed on the sites which the appellant considers a double counted, because the council has agreed they were double counted. So 1 to 4 are no longer in dispute.
Does that make a figure to the council's position? It's a difference to the council's position.
Yes, I think there is actually an error in row 1, or the comment about double counting. Originally, the figure in there was 8, so that was corrected. Rows 2 and 3, we had a 0. Mr. Tiley and I had a private discussion. Was it the 12th of August? I think it was something like that. A couple of weeks ago, anyway. So, and I clarified what we had done there. So rows 2 and 3 are included within the total of 5 within row 4. So we are agreed that the supply from those sites is 9 from those 4 rows.
Sorry, so the same is also true of row 5. We're in agreement there. It was double counted, and both parties have agreed to that correction as well. Sorry, I thought it was rows 1 to 4, but it's 1 to 5.
Right then, so on the supply column, just to confirm, what should I be looking at for the rows 1 to 5?
The positions in both columns are the current positions of both parties, and they sum to the same. So the row 1 were agreed for, row 2, 3, and 4, which is the same site in aggregate, were agreed as 5. Row 5 were agreed as 1. So yeah, so there's on these sites we're agreed a deliverable supply of 10 dwellings, and there's no dispute between the parties on that.
So 1 to 5 in total is 10.
Yeah.
Do we need to? Does anyone want to raise any other points on 1 to 5?
I'm just wondering, so if at the end of this exercise it might be helpful to have a summary of where we get to, because it's done by categories, and I don't see at the moment a handy differencing between the categories. So in other words, this category would be agreed 10, and then there'll be others where there'll be differences perhaps. Can we do that?
Yeah, we've shared a spreadsheet which does exactly that, so we do have that to hand. So
Helpful, thank you. Now, in terms of the council's view on deliverability versus developability, is there anything you want to say at the outset?
I think if we were to refer to specific sites on here, if we look at the permissions in principle, noted Mr. Tiley and his colleagues want to argue for 0. I think we would simply say as an LPA, the government introduced permission in principle 8 years ago. It's intended to be an alternative route to get planning consent. It is noted that technical details are supposed to be submitted, but many of these still have at least 2 years to run. The build-out times are very short, so we don't really think it would be feasible to strike out a lot of these sites that have been granted consent within a year, the last year, simply because they've not had technical details come forward yet. If that were to be the case, and I appreciate that will be your decision, sir, it does throw up an interesting little conundrum in that these sites would still be likely to get their technical details consents come forward, but they would all be unidentified sites, i.e. windfall.
Thank you. Mr. Tiley?
sorry, sir, Mr. Davies jumped several pages down the Scott schedule and dealt with permissions in principle. Dealing with your question, sir, and how one determines a deliverable site, the definition is set out in the framework, and it's very clear that in order to be considered deliverable, sites should be available now, offer a suitable location for development now, be achievable with the realistic prospects that homes will be delivered on the site within 5 years, and then sites which do not involve major development and have planning permission, and all sites with detailed planning permission, should be considered deliverable until planning permission expires unless there's clear evidence that homes will not be delivered. And for category B sites, which are those which have outline planning permission for major development, they're allocated a grant of permission in principle, or those identified on a brownfield land register should only be considered deliverable where there's clear evidence that homes will be delivered on site within 5 years. And we're agreed that's the appropriate test in the statement of common ground, sir. I think it's in paragraph, let me try and find it one moment. Yeah, paragraph 2.15, sir. So I don't think there's any dispute between us as to how one assesses deliverability, and it's clear from the framework.
Okay, thank you.
But if we proceed to consider the sites in the schedule, sir, again, sites 6 and 7, the council had previously included, but now agree they're not deliverable. So these are sites with planning permission for holiday accommodation, and they provide, or all agreed those shouldn't be included, and therefore provide for 0 homes. The first contested site is site 8, sir.
Yes.
I don't know if you want me to lead on it or the council.
Just to quickly check back, sir. Yes, I don't fundamentally disagree with Mr. Tiley's points with regard to holiday accommodation. the reason that some of that information was in there incorrectly is due to the arrangements which I inherited and the involvement of the county council monitoring. There's still exercises to do in terms of going back to provide some comments on the draft data. They undertake final checks. It's quite apparent, and I do not dispute those sites should not have been in there. So it is something else we do agree on.
Mr. O'Brien-O'Reilly, is there anything you wanted to say there? Yeah. Sorry, Mr. David.
Yes, I think site number 8. That would be a C3 apartment. So that's our position. I appreciate that Mr. Tyler disputes that. We could mutually bring something to your attention in regard to row 9. Again, we need to provide a verbal update because this has now expired.
Is site 8 agreed as 0 or not?
Yeah, we agree that row 9 is
8.
Oh, 8. Well, we say 1 because that would be the apartment would be a C3 use.
So if I can
So, enough for clarity, that is what the planning application said. So there's no, the application form did say that there was one new market dwelling being provided as part of this application. I think there's obviously, I know the appellant's position, but the legally it can be how it's chosen to be used is different to what it is lawfully, I would suggest.
So lawfully, it's a full flat.
Yeah, it's on the application form. It was considered as that part. It's on the application form. It's a public document.
Sorry, sir. Whilst on the application form they did apply for a C3 use, what they actually applied for was a flat ancillary to the primary retail use. As you will be aware, sir, because it forms part of the primary retail use, this will fall in use class E and therefore does not comprise a dwelling for planning purposes. Furthermore, sir, even if it was wrongly considered to fall in use class C3, it does not have its separate access. It will not be subject to council tax because it's part of a business, and therefore it wouldn't form a dwelling for housing land supply purposes as set out on page 33 of the Housing Flows Reconciliation Guidance, which you have at CD 13.36. So firstly, it's not a dwelling for planning purposes, and secondly, it's not a dwelling for housing land supply purposes. 13.36, sir.
13.36.
That's a 1 plays 0, isn't it? 8.
Yes, it is. It's not it's not a massive.
But they tot up. Yeah. Okay.
I do think the key word in there is associated with. So, or keywords. Anything from the council on what Mr. Tarley said?
Just there's no condition restricting it, and in theory, it could be subdivided without any need for planning permission. Internal entrance could be provided. So yeah, I'd suggest that.
Is it a separate planning unit at the moment?
Part of the application. We'll have to confirm. Sorry.
Yeah, we can confirm.
Okay then, row 9, Mr. Tully, you were saying?
Sorry, it's Mr. Davey. Actually, there's a mistake, as Mr. Davey was saying, that we've discussed. The council's position is that this isn't deliverable, and rather than that 8, it should have a 0. And in fact, the total at the bottom of this table assumes that it has a 0, so that 8 is just a mistake and should be crossed out. It should be 0. Yes.
Right. So row 9's agreed then.
Row 9 is agreed that it's not deliverable. Yes.
Thank you. Row 10.
Who would you like to lead, sir?
Go for it.
Thank you, sir. This is a site which had permission in principle, but that permission in principle has now expired. As it had permission in principle at the base date, it should be considered deliverable but only if there's clear evidence that completions will be achieved. Given that planning permission has expired, it would appear that completions won't be achieved, and there is certainly no clear evidence to suggest that completions will be achieved as required by the framework.
Yeah, and on that particular site, that is correct. The permission did expire, so that will now no longer form part of the supply, but it was in there at the base date because there was no indication it wouldn't come forward at that time.
So do you agree that that should be a 0 now?
Yes, yeah, that is correct. It's as a consequence of post-base date activity.
This is the 5-year land supply from 1st of April, isn't it?
Yeah.
Yeah. For clarity, that's because this document we're working through is the 1st of April 5-year land supply, so there will naturally be some changes. It's not that we've
I think as long as I get something at the end of this that gives the current position between the parties as was agreed, I think that's what I can work off. Good, thank you. Right, so we move on to permission with principle, but no technical details in the next few. And let's go back to what you were saying a moment ago, Mr. Tiley, about whether or not I should consider the deliverable based on the fact that there's obviously a fairly large time frame, though. I mean, will it take 5 years practically?
What the MPPF is clear that to consider these sites deliverable, you need clear evidence that completions will be achieved. And in my experience, it's very commonly the case that permissions in principle are never implemented. They're primarily used, in my experience, to increase the value of land rather than with any intent of delivering. They're an easy way to get planning permission, increase your value of land, and then not implement them. There is, sorry, I should say actually at the outset that on row 11 and row 18, yeah, those two sites have now gained full planning permission, and therefore
Hang on, just before we go there, I just want to ask you about the difference between this concept of delivery and the practicality of deliverability.
Yeah.
I mean, you say that the intent won't be there, but to deliver them, and quite often they're not, as you said. But that's not accounted for in the overall looking at deliverability and the concept of deliverability.
It is because the framework requires clear evidence that completions will be achieved on these sites. So the council needs to provide clear evidence. Whilst they obviously could be delivered, equally they may not be delivered. The framework is clear that to include these in the deliverable supply, you need clear evidence that completions will be achieved. And that's what we're lacking on these, apart from on, as I was saying, sites 11 and 18, both of which have since gained full planning permission. And therefore I agree with the supply of the council on those two. And that's reflected in my updated note. Yeah, all right, fine.
Just want to ask the council if they want to respond to that.
I think in some ways the comment has been, well, Mr. Sally's comment about the sites benefiting from permission in principle, but there's no application for technical details, no clear evidence of completions. As I said a few moments ago, there's a 3-year window for those technical details to come forward, and site 18, the comment is that the PIP remains valid in January 2027. So given that we're in August 2026 now, how would you recognise that that's come forward, but then sites where the outline or the PIP is valid until 2029 won't? And this is really the challenge, because local authorities don't build houses. We recognise what the MPPF says. Mr. Talley may agree with me that it would be very helpful if the PPG perhaps went into a little bit more detail on some of these timeframes. But we can only do what we have with the information we have available to us. We do obviously contact developers for updates. They're not always quick to respond, but our position would be that these sites are capable of coming forward.
In your view, is
piggyback on that for a point. I think reality is one of the big issues is that the appellant and the council have a very different stance on what classes as clear evidence. I think, as a council, our opinion is that professional judgment, historic evidence, etc., nature of the development, scale of development, all of those things are an indicator. As Ms. Tyler said, a number of these have already been given full planning permission, and to be honest, that does seem to be quite a common feature here at Fenland, that, you know, applications do get a PIP and then they come back with full permission. But that would still suggest, in my mind, they could be built in 5 years, even if that was the case. I think, to a certain extent, I think that's the crucial point, and the crux of the matter on that goes to the heart of this whole Scotch schedule is about what is considered to be clear evidence. And I would suggest that the appellant's threshold is, or standard is much higher and much more challenging than what the MPPF would reflect. I think that's really a matter for you to decide, you know. And I think, I don't want to say, I think if we're just conscious of this when we go through the whole schedule, otherwise we're going to spend hours saying exactly the same words on every single line almost. And I think if we can just all acknowledge, I think, you know, the other side are nodding and smiling. I think that we agree that it might save some of your time and our time if we just accept that on a lot of this, that's the difference is. And we can obviously still help you and aid you, but rather than repeating the same wording on however many lines, it might just sort of save some time here if we just acknowledge that's actually the big difference, I would suggest.
So, thank you. In terms of the individual rows, then, what were the differences that I'm looking at?
Should I respond on the point of clear evidence and difference first, or do you want? I mean, in terms of the rows, it's 11 and 18. I agree are now deliverable because they've got full planning permission. So I've conceded those, and that's reflected in my updated note, and that adds 9 dwellings. So there's a remaining difference of 57 dwellings from this source. But in terms of clear evidence, if we turn firstly to the framework and the definition of deliverable, which you find on page 104, sir. I've already said this, but the definition deliverable part B, so these are sites with permission in principle, which fall in part B of the definition. They should only be considered deliverable where there's clear evidence that homes will be delivered on site within 5 years. The council's suggestion is the fact they've got permission in principle means that they should be considered deliverable, i.e. what the council are doing is applying the category A test rather than the category B test, which is fundamentally inconsistent with national policy and would entirely obviate the definition of national policy. Then when we turn to clear evidence, sir, if we can turn to the PPG, with the housing supply and delivery section, this sets out what clear evidence may include. The PPG 68-007. Yeah, is that under housing supply and delivery, sir? Yeah. So halfway down that, it says such evidence to demonstrate deliverability may include, then it provides a series of examples of the kind of bar that's likely to be required for a site in category B to be considered deliverable. And for example, it says firm progress being made towards the submission of an application. For example, a written agreement between the local planning authority and the site developers, which confirms the developers' delivery intentions and the anticipated start and build out rates. Firm progress with site assessment work. So the bar set by the PPG is quite high, sir. And indeed, that's translated through a number of appeal decisions which you have before you, sir. Firstly, I draw your attention to, let me get the CD reference, the Stapley appeal decision, which is a recovered, sorry, I can't remember if it's a call-in or a recovered appeal decision of the Secretary of State. And you should have it at, where are we? CD 1316, so. And if we turn to paragraph 21 of that, 21, sir. So this is the Secretary of State's interpretation of the PPG and the requirement for clear evidence. Halfway through that paragraph, 5 lines down, the sentence starts, he considers, i.e. the Secretary of State considers that on the basis of the evidence before him, the following should be removed from the supply. Sites with outline planning permission which had no RM applications and no evidence of a written agreement. So there you see the Secretary of State saying, I need something fairly substantive, either a reserved matters application or a written agreement from the developer in order to consider a category B site deliverable. Similarly, if we turn to the Sturry appeal decision, which you have at 13.23, let me see if I can find the paragraph number. I think it's paragraph 22. Sorry, 23. So again, this is dealing with the deliverability of sites, and it sets out that for a number of the disputed sites, the council's evidence is founded on a site-specific statements of common ground, which have been agreed with the developer or landowner of the site in question. I appreciate that PPG refers to statements of common ground as an admissible type of evidence, and I've had full regard to that advice. But nevertheless, the evidential value of any particular statement of common ground in this context is dependent upon its content. So in this case, the inspector has found that even where there's a written agreement with the developer, that may not in itself provide clear evidence. And that there's similar points made in the Cadwell appeal decision at 13, which you have at CD 13.27. If I can find the relevant paragraph. Paragraph 57. The paragraph 57 sets out clear evidence requires more than just being informed by landowners, agents, or developers that the sites will come forward. Rather, that a realistic assessment of the factors concerning the delivery has been considered. This means that not only are the planning matters that need to be considered, but also the technical, legal, and commercial financial aspects of delivery assessed. Securing an email or completed pro forma from a developer or agent does not in itself constitute clear evidence. So once again, we've got a clear finding from an inspector saying that even if you provide written evidence, that may not be sufficient. Sorry, that's CD 13.27. And indeed, sir, I've represented housing land supply matters on approaching 200 appeals. I don't know how many of those have been since the current definition, which was introduced in 2018. But I've never encountered an appeal where there's no written agreement in support of at least the majority of sites from the other side. And that's the position we find ourselves in here. This is a highly unusual position where there's literally no evidence in support of any category B site. And following the approach set out by the Secretary of State and consistently by inspectors, those sites should not be considered deliverable as set out in the framework as a consequence, sir.
Permission in principle, Council. What's your approach?
Council acknowledges obviously the content of the PPG, and obviously it says evidence may include. It's not explicitly limited to those 4 categories. I think, appeal decisions are always useful, but as we all know, each application must be determined on its own merit. We don't know the details of what was being said. We've all seen councils roll out the same letter basically year after year from the same developer saying the site's going to be built out at this rate and it's never implemented. That may be the evidence that was before us here. We don't know. And what I would suggest is the small scale of the missions in principle, the limited size, it is reflective of the amount of evidence you would need. I would suggest that would go to the heart of the matter with all of these. There is an ability to have some level of planning judgment. I would think that if you're looking to push significant figures, that would be well above what, as a professional judgment, then you would need significant evidence to demonstrate that. But if you're looking at a reasonable progression, I don't think you can say we are trying to force category A into category B. But I do think there is a consideration of the government's approach to Category A schemes, which is obviously very small ones, and well, not very small, but 9 and under, and obviously there's some level of direction of thought in there.
You mentioned that the four criteria aren't exclusive. Oh, sorry, inclusive, exclusive. I think you probably know what I mean there.
Yeah, I know what you mean.
What you
I'm
said.
not sure which one's right either.
But the PPG does say that they are namely those, just to split hairs there.
For sites that fall within the definition of B above, advices that clear evidence may include.
I'm looking at the reference that Mr. Tiley gave me, which is paragraph 7 of the Housing Supply and Delivery PPG
Sorry.
section.
So it's uploaded the wrong thing when I googled. So what's that? So I have to go back in.
That's okay. It's Housing Supply and Delivery.
Yeah.
This is the subparagraph. What constitutes a deliverable housing site in the context of plan making and decision taking?
Yes, that's correct.
Well,
Paragraph 7.
The wrong thing came up with technology.
We'll have a break after this, I think.
Yeah. So it says, so namely is in relation to the four have outlined planning permission, are allocated, but it says the evidence, it still says may include.
Oh, may include, yes.
Yeah.
That's the next section, yeah. Okay.
Yeah.
Mr. So you've kind of covered this already, but just to confirm, Mr. Tiley said that in the council's case, as with several of or most of these rows, that the council has no firm evidence.
In relation to permission in principle, as we were saying, we do not dispute what the PPG says. We do not dispute that it says there will be a need for the technical details to be in place. But the NPPF definition on deliverable does refer to 5 years, as does 68007, not just 3. So that in itself would infer that there has to be a realistic time frame to be allowed for any follow-on technical details applications to be submitted. Again, I did discuss this with Mr. Tiley in private. This is not set out in national policy, so we do understand it appears as a binary choice, but we're forecasting, and that realistic prospect of delivery is not necessarily translatable into a guarantee, because circumstances can change. And to some extent, I think our point is clarified in the fact that we've now got a PIP with a consent valid until January 2027 that's now been granted full consent, but then potentially the appellant wants to discount sites where there's still over another 2 years left for those technical details to follow on. That would be rather odd to do that, and as also mentioned, if anything was to be taken out because the technical details haven't yet come forward, it certainly doesn't mean that they won't, because of the nature of the market and in this borough. So those sites would then be windfall when those subsequent applications come forward.
Thank you. Mr. Tiley, could I ask you for your final say on everything up to rows 23?
So I might have to ask questions through you, sir, because I'm lost as to the council's position. National policy is clear that for sites with permission in principle, they can only be considered deliverable where there's clear evidence that completions will be achieved. What you've heard from the council is that the existence of permission in principle provides that clear evidence. That would be entirely counterproductive, sir. It would obviate the entirety of the definition of a deliverable site, sir. So can I have clarification that the council agreed that you need clear evidence and that they have no clear evidence beyond the existence of a permission in principle, which the MPPF is clear doesn't provide clear evidence, because there wouldn't be a requirement for clear evidence if that provided clear evidence, if you see what I mean, sir.
With respect, I think that's your interpretation of what the council just said. So I think what we have here is two divergent points which aren't going to be agreed.
Yeah, with respect, that's not the case.
Yeah. So we're not going to reach any common ground there other than what we've got. And we can have a cup of coffee or tea.
Thank you, sir.
I'll give 15 minutes for everyone's excitement to calm down, and we'll come back at 11:45. Thank you. Thanks, everyone. Okay, turning back to the slot schedule. The next site is one with a one home difference that the appellant considers was delivered before the base date. Any comments on that one? Okay, that's row 24, back of the statement of common ground.
Yes, thank you, sir. This was one of the sites that did need further checking. I acknowledge Mr. Tiley sent in a street view image. I can't refute that per se. It's clear there is a completed house there. It's not immediately clear as to when, but it's clear that there is a completion.
So that this is a 0.
So we can, I think, yeah, on the balance of probability, we can probably agree that will be a 0 because we can't refute that date of 2023 at this time.
Thanks. Okay, now we've got our hangers around us from rows 25 onwards, with an extensive record of non-implementation. Mr. Tiley, could I ask you to lead on these ones, please?
Thank you, sir. So this is a group of sites which contribute 16 units, upon which planning permission was granted many, many years ago, and then a technical commencement was achieved, but then the developers left site and haven't made any progress in many years. Now, LPAs typically discount such sites. Indeed, when I last worked for a council, we after if there was no progress on a site following a commencement for 3 years, we didn't continue to monitor it or include it in the supply. And indeed, the council has done precisely that in previous assessments. None of these sites were included in the previous 5-year land supply assessment of the council because they'd acknowledged that there was an extensive record of non-implementation, and as such, that provided clear evidence that completions wouldn't be achieved. I understand that they've been included by the council this time because the council are in the process of checking with the county council as to whether or not these are deliverable. But in the absence of a completion of that consultation, the council have just put them in the deliverable supply as a default rather than actively contending that they necessarily are deliverable. Now, not only does the track record on these sites provide clear evidence that completions will be achieved, the PPG 3-019, which is under the HELA section, identifies that the record of implementation will be material to whether they should be considered.
Could I get that again? Sorry.
3-019 identifies that the record of implementation will be material to whether sites should be considered to be available. And given that developers have left site many years ago, I wouldn't categorise these sites as being available now in accordance with the PPG, such that they are not deliverable. Similarly, given the track record on these sites of many, many years of non-implementation, I don't think there's a realistic prospect of delivery. So I think it falls foul of 3 of the tests, namely that they're not available now, there's not a realistic prospect, and there's clear evidence that completions won't be achieved. So,
thank you. The schedule says on all of the 7 sites in question here, Council, that you may need to discount the sites. Have you done any further work on that?
So the process which Mr. Tiley described there is it's not entirely accurate. As I said, I've had to work with the arrangements that I inherited. So,
oops, I didn't know that did that. Sorry, Mr. Davey. I just went to put my microphone on and hit the wrong button. No, the steam was going. I thought sorry, I was having trouble hearing you. Was where I was going with that? Sorry about that.
Yeah. I think the difference is really that in this district, the county council has a significant involvement in housing monitoring. So usually at the end of the financial year, then data on permissions that have been granted and completions and so on are recorded. The county check the status on sites, if the draft information they've had is correct. Now, usually what happens is that a draft, rather unwieldy, ugly Excel spreadsheet is issued at the end of July every year. The authorities have usually around a month to go back with comments. And what that does is give an opportunity to identify anomalies. Now, part of the reason that we had to put together a draft schedule in time for the appeal, and what led to some of the early double counting, was the fact that there were entries recorded as negatives where there was a demolition, and then others then recording, so 4, 5, 7, 22, how many ever homes were on that scheme, but the demolitions were recorded as a separate entry. So this has, it's had to be prepared using draft data, which required further checking. Clearly, again, if there are sites that were included because they have been granted consent, and once again, if demolition is required through those works, that consent has been implemented, so it will never lapse. If there are records that found their way back on there, we would need to take it up with them and say they need to be removed because they don't meet the MPPF tests. So again, I don't dispute any of Mr. Talley's comments on here. It may well be the case that there's been no further progress towards delivery in 10 years at Halfpenny House, for example. If that's the case, it clearly falls foul of the PPG.
What you're suggesting, therefore, is that there isn't clear evidence in these cases.
They need further checking. That's all I can say at this time. But if they've been removed from the previous schedules, which were all based on finalised, cleaned up data, which is issued to the authorities at the end of September, then yes, clearly these are mistakes, and they would need to be removed because they aren't PPG compliant.
So do we take the 16 off then?
I think that's something I'm going to have to consider.
Yeah.
Position of agreement that in the absence of any further evidence for you, these which were not in previous iterations but have slipped back onto this, we just agree to take them off, don't we?
Sorry, would you repeat that?
I don't want to ask questions across the floor, which is why I'm doing it through. But I say, if these are recorded in this schedule but weren't previously for the reasons given, namely they're old, implemented but not continued with, then subject to you receiving additional information in this inquiry,
yes,
I think we're agreed they need to come off because they're contrary to the PPG.
That does seem reasonable, yes. Thank you. Any other comments, Mr. Davey?
No, sir.
Thank you. Okay, then moving on to row 32. Fairly familiar territory for an inspector, I think, doing 5-year housing land supply, and that's outline sites which have a variance in their current positions. So I think we'll have to deal with them one by one rather than a combined approach. So row 32, first of all, then. I think I should probably start with the council on these ones to ask them to defend their position. If there's anything that we want to add to anything that's already on this schedule.
Yes, so there's not really too much to add. Again, the active outline consent was in place on the 1st of April. A reserve matters is in place for one, and the other plots are being sold for self-build. Now, we recognise the comments there. The 1.5 hectare site is, of course, larger than 0.5, so it would be classed as a major development under the MPPF. But again, the build-out rate would be akin to a smaller site, a minor development, because it's 9 self-build in total. So we're perhaps returning, in this section, we'll be returning to some of the previous discussion around emissions in principle. And again, the threshold of what's deliverable and the likelihood over 5 years, because we're dealing with a realistic possibility. And just because the plots are being sold as part of a land transaction, that again itself doesn't mean there'll be zero delivery at this time.
Thank you. Mr. Tully, row 32.
There's not much to add, sir. I think the council, it was at least implicit from what the council said, that this is a major development which can only be considered deliverable where there's clear evidence, and there's no clear evidence on the remaining 8 units beyond the fact it has outline planning permission, which in itself can't provide clear evidence because sites with planning permission, outline planning permission require clear evidence to be considered deliverable. Should we go back to the same debate as with permission in principle, sir?
Thank you. Any comments on row 33 from either party?
Still, a slight difference to the previous conversation, obviously, is that this already. Sorry, road fence off moved. So I was just thinking in relation to 32. Sorry, because obviously one has the reserve matter, so I would suggest that does show. So in relation to 32, one has been given obviously reserve matters, so I would say that is different to some of the other sites we talk about. Obviously, there is clearly a direction of travel in relation to delivery on this wider site, but yeah, it's only slight variance to maybe some of the different ones. But this is obviously at the end of the day a matter for you coming around.
Is a direction of travel represented in your view, Mr. Tyler?
So this is for 9 self-build plots, so they will each be delivered individually by separate builders as self-builders. So the grant of RM approval for one self-builder on one plot has no relevance to whether or not RM will be approved for the remaining plots, sir.
Thank you. Row 33.
Similarly, the update that we've had from the agent is that the parcel of land is currently being sold to one of our clients. Once this is finalised, an application will be forthcoming. It's covered by an outline consent that's still valid until December, and therefore it wasn't unreasonable to include that on a schedule with a base date of the 1st of April.
Any sign of them getting their skates on through the council?
Sorry, sir.
Reserved matters likely to come in before December?
We contacted in respect of that. The agent said that the parcel of land is currently being sold. An application will be forthcoming once that transaction completes. So it's really down to how long that will take as to whether or not anything may come forward in that time.
Thank you, sir. This is the one site where the council allude to some evidence having been provided by an interested party. However, that evidence isn't before the appeal, sir. We don't have the written agreement required by the PPG as an example of the clear evidence. And what we understand from it is that a developer has yet to be secured. So therefore, we don't have a developer on board who can provide an indication of when completions will be achieved. We don't know, whilst we're told that an application will be submitted, we don't know what that application will be for. We don't know when that application will be submitted. We don't know when completions will be achieved thereafterwards. So I would suggest that whilst there is some evidence, it falls far short of the clear evidence required by the guidance on this site, sir, inconsistent with the appeal decisions that I've taken you through previously, sir.
And I think just to slightly moderate that, we are dealing with a schedule that had a base date of the 1st of April, so there was still 8 months remaining at that time. Appreciating we're now at the end of August, so the position does look perhaps slightly worse.
Thank you. Right, row 34. Any comments from either party?
So as with many of the sites, this is a site with no application to discharge condition, no application for the approval reserve matters, and literally no evidence to demonstrate. Sorry, there was one application to discharge conditions, but that was refused. There are no other applications to discharge conditions. There's no reserve matters application. and there's, as far as I can see it, no evidence whatsoever to suggest that completions will be achieved.
Thank you, Mr. Davey. If you wish to respond.
I think again, just from the council's perspective, again we're dealing with a schedule with a base date of the 1st of April. The application to discharge was considered to be intent to proceed. And that is referred to in the PPG as one of the possible things that can constitute evidence. The outline, of course, is still valid until October 2027 as well, so there still remains a good amount of time to resolve the issues.
What was condition 12 in relation to, please?
We'll just check that for you. That's archaeology, so.
Thank you. Row 35.
Again, the outline is still valid until November 2028, so the developer has until that time to submit the reserve matters. It would meet the major definition again, although it's 7 dwellings, but the size of the site is 0.69 hectares. But there hasn't been an application at this time.
Thank you. Row 36.
Exactly the same as the preceding site. No applications to discharge conditions, no applications for the approval of reserve matters, and no evidence whatsoever to demonstrate that completions will be achieved, sir.
But the outline was granted less than a year ago and remains valid until October 2028.
Thank you. Row 37.
Same as the preceding 2 sites, sir.
Yeah, the outline consent is still valid for 2 years. So we still think there's plenty of time for those technical details to come forward.
Thank you. Row 38.
So this is a site for 58 dwellings. Granted outline plan permission in December 23. There are no applications to discharge conditions, no applications for the approval of reserved matters, and no evidence at all that homes will be delivered. And indeed, on this site, I've been approached by the applicant to help them reconsider their options as to how they progress this site. I can't disclose any detail because of client confidentiality, but I am permitted to say that they are reconsidering their options, and that's, to my mind at least, provides clear evidence that completions, well, depending upon the outcome of that reconsideration, that at least entertains the fact that completions won't be achieved, and therefore there can't be clear evidence that completions will be achieved.
I just want to check that I can take that into consideration as evidence.
Yes, I mean, Mr. Tini made the point about the council's evidence, saying, well, there's no evidence for this inquiry. As you've correctly identified, you can't disclose the full details of, for example, what those various alternative options may be and why one might proceed over the other. So I think you've got to be really quite careful about treating that as evidence of a lack of clear. I mean, it's helpful, and I appreciate you offering that to try and assist you, sir, but I think in terms of decisions you come to, there's a real difficulty with that evidence. It's only limited, and it can only be limited because of client confidentiality, and I don't think it can be described as clear evidence in those circumstances. So I'd urge you to treat that with an awful lot of caution.
So I'm not putting forward positive, clear evidence that completions will be achieved. I'm saying that I know that there are issues. And in fact, the client has said that they're happy for me to say that they are reconsidering their options. So that's not a client confidential issue. So you can take that into account.
In terms of the degree of weight which I can give it, it's sort of anecdotal. So unless I would invite you, if you want to submit some written evidence to the inquiry. But again, that could be on a scale of weight that I give it, depending on what you submit.
Fine, sir. But just to come back to the point, we need clear evidence that completions will be achieved. So you could disregard everything I've said, and there's still no clear evidence that completions will be achieved, which is the test required by national policy.
Yes. Okay.
I think equally,
yeah.
sir, we did contact the developers for an update. They didn't respond to us, so there's not much more that we can do, because we recognise that we did need an update on the developers' plans for the scheme.
Because this is a fairly large site in terms of numbers.
It is.
So that's why I've offered Mr. Tiley the opportunity to submit further written evidence.
Just because the council have said that they tried to contact developers and received no evidence, I'm intrigued by what their clear evidence is that they rely upon to include this site in the supply.
Thank you.
So we contact them for an update on the information on what's going to happen, because the outline does expire in December 2023. It is a significant site, and again, obviously, in light of the purpose of this roundtable discussion, we need to know what the plans are.
Also, I would suggest that the fact that they have contacted Mr. Tiley shows that they do look to deliver something on the site. I'd appreciate that clear evidence they're looking to bring forward something, and appreciate the update.
That's just cheeky. So you've heard it's the council who need to bring the clear evidence of the figures that have come through. They're claiming 58. There's no clear evidence. They contacted the developer and they got no answer. So even if you were to entirely discount what you've heard from Mr. Tiley, there's no clear evidence on this side. But we'll supplement this if necessary.
So if I cut it up, I mean, obviously the council have characterised in this table in a certain way. It would be open to you, for example, to find that it fell within the first part of the definition of deliverable, i.e. site which is for housing or the pitches, etc., available now or for a suitable location for development now, and be achievable a realistic prospect that homes will be delivered on the site within 5 years. So it doesn't require a grant of planning permission. There has been a grant of planning permission here, which has obviously showed the acceptability of the site for a certain number of homes. And what you're being told is, oh, well, there's an intention to do something here, it may be different to what has been granted. So you could disagree with the way in which it's been characterised by both parties and find that actually it does fall within the site deliverability, having regard to the first part of the definition on page 104 to 105 being PPF. That's just something to bear in mind.
So So what I've understood from Mr. O'Brien O'Reilly is that one should just apply the introductory paragraph of the definition of deliverable and disregard the two tests within the framework. That can't be right. That would be of interest to the courts, I would suggest. So you must apply the definition as a whole.
Okay, thank you. I take what you've said on board. Thank you. Right. Next is another big one. It is row 39. And this is care home and dwellings. So we're only looking at the dwellings.
Sorry, so this site gained outline planning permission for a care home and for up to 60 dwellings in June 2023. The two parts of the site are being brought forward by separate land interests, so they're not in any way connected. The care home has got reserved matters approval, and we agree that's deliverable. It's the up to 60 dwellings, no application for reserved matters, and as far as I can see it, there's no evidence that those will come forward. And indeed, the Council Scott schedule says that they are awaiting an update. And presumably, unless they've received such an update, there is no clear evidence.
But we have implementation, is that correct?
For the part of the site under a separate land interest pursuing a separate scheme, yes. Sorry, I don't think it's commenced from memory. I think it's just got reserved matters approval.
No reserved matter approval for the housing element?
No, so a colleague did contact the developer, and we haven't heard back in respect of the apartments. we did contact for, I think, the reasons are fairly obvious under the appellate's comment, because the 60 dwellings were granted in June 2023.
Yes. Given that this is implemented, is what I take from that. Is there any time limit now on when reserved matters applications come in, given that they've made some already? I just need a refresher on the rules there.
So maybe I can assist with that. The conditions are slightly subject to interpretation, shall we say. So there's one outline planning permission for both parts of the scheme. There's reserved matters for the care home. Condition 1 is reserved matter will be submitted within 3 years. Now, it's unclear, because the condition is written awfully, whether that's all reserved matters or that there will only be one reserved matter, which is how it would be read, in which case the care home can't be lawfully implemented. But the condition is written terribly, so.
Would the council find a reserved matters application after June to be valid on the housing?
Sorry, sir. Would you repeat the question, please?
Would the council find a reserved matters application after the expiry, the on paper expiry of the outline, to be a valid application?
My understanding would be that wouldn't be possible. But that's my understanding.
Just heard from Mr. Tiley that the wording of condition 1 is open to interpretation.
I'm sure there will be a correct interpretation in the courts, but and read on its face, it would be that there should be a single reserved matters application for the entirety of the scheme. But I'm not an expert in legal matters, so I'll leave it to others.
I didn't catch, forgive me, I didn't catch Mr. Davies' answer to your question, so that's my fault, because he dropped his voice. Your question was, would reserved matters post June 26th be
Yes.
added?
We're just
And
looking at the
Mr.
condition
Davies'
now.
answer was yes or no.
That's okay. Yes, I'll just, could you repeat your answer there, Mr. Davey, and I'll just give Mr. Lee a chance to check the condition while you put.
I just say my understanding would be that if that application has expired, it wouldn't be possible for the separate reserved matters to come forward. But I'm not too familiar with the detail of the scheme because I wasn't working for the council at the time.
So, see, there was an application 2024 today of conditions to allow it to be phased. That's what the description is. So,
That didn't extend the outline permission at all, though.
legally, yeah. Okay. That just jumped up. I didn't see,
So perhaps page 43 of Mr. Davies' original proof of evidence might assist. The third bullet point thereof. Page 43 of the hard copy document. The third bullet point. It's PDF page 52, sir.
Could you give me the reference
The
again?
third bullet point on that page. Oh, I'm sorry, on page 40. Sorry, PDF page. Sorry, it might be page 53. Sorry, PDF page 53.
Yeah. Okay. PDF page 53. Okay then.
So can we agree then to knock off 60 then?
That was where I'm trying to get.
Yes,
So if that's the
getting in your way.
council, if the council wants
So could
to
you
reconsider
confirm
its
the document
position, there.
reference, please?
Is your proof?
My proof was my original proof was 1407. There's no page 53 or 43.
So yes, your proof, actual page 43, PDF page 53.
The final page of your original proof of evidence, Mr. Davey.
Oh, that's easier. Last page.
Yeah, sorry, I hadn't realised. But
yeah, Variation of conditions is the more important one. So I think the variation of conditions is the more important decision notice because it does explicitly break it out into the fact that multiple reserved matters can be submitted. But it also states that application proof of reserved matter shall be made to local planning authority before the 5th of June 2026.
So that goes back to my first question. Then, can we consider, based on the base date between April and the expiry in June, is that a reasonable? Is that clear evidence? That's what I'll be seeking to answer.
I think we can accept this probably can be struck out.
Right. Okay. Thank you.
Yeah, which again is what I said in bullet point 3.
Thank you very much. Row 40. Which is 100 homes in question. Any comments from either party?
Sorry, I missed the final.
100 homes, any comments?
Yes, so this site has hybrid planning permission for including full planning permission for 100 homes and outline planning permission for 200 homes. The 100 homes benefit from the presumption of deliverability and are therefore agreed to be deliverable. However, it would be very optimistic for those to be achieved, as set out in figure 3.2 of CD 13.35, which is the start to finish report. On sites of this size, it takes circa 3.2 years from the grant of RA.
Could you just pause while I bring that up?
Yeah,
Thank you.
certainly, sir. If I can bring it up. CD 13.35.
Litchfields, thank you.
Yeah.
Again, the paragraph number, sorry.
So it's figure 3.2, which is on PDF page 7.
PDF page 7. Thank you. Thank you.
There's figure 3.2 to the top right of the page. So you might need to scroll across to the right, I think. Oh, no, you can see it, sorry. Mm-hmm. Yeah, you can see there that the Litchfields report identifies the average lead-in times for sites of different sizes. This site is a site of 300 dwellings, so it would fall in the bottom bar. And you can see that the green section, the blue section is the time from a submission of an outline planning application until outline approval. The orange section is the time from outline approval till reserved matters, to the grant of reserved matters, and the green section is the time from the grant of reserved matters until the first completion. So you can see that on sites of this size, it takes roughly 3.2 years from the grant of approval of reserved matters until the first completion. So you'd be expecting that the first completions on this site, bearing in mind reserved matters were approved. Let me see. Got too many documents open. Reserved matters were, full planning permission was granted in February 2026. Assuming the lead-in time for a full planning application is the same for reserved matters approval, you would expect first completions to be achieved in mid-2029, 2030, which would allow 18 months within the 5-year period to facilitate those 100 dwellings. So the 100 dwellings is optimistic but achievable.
Right.
There are, on the outline, there are no applications for the approval of reserved matters, no evidence that any completions will be achieved pursuant to the outline, and in light of the fact that it's optimistic to include those 100 in the supply, it would be unrealistic to include any more than the 100 from the outline, which will follow the full. If that makes sense, sir.
If a reserved matters application was to be submitted for those in the meantime, would that be clear evidence of deliverability?
If a reserved matters, that would, no, the submission of reserved matters alone doesn't provide clear evidence. You would still need a realistic prospect of delivery. And as I've said, realistically, you would only expect about 100 homes to be achieved from this site, even if another reserved matters application came in today and was approved forthwith. So my position wouldn't change even if another reserved matters application came in, because it wouldn't be realistic to include more than 100 dwellings there.
The council for its response.
That's of course entirely down to build out rates, which do vary from developer to developer. I don't think we can really say a great deal more than that. If the developer wants to prioritise the completion of a particular scheme, they can commit more resources to it.
Okay, where is the clear evidence in this case then? It should be included in the schedule.
Well, the clear evidence, the outline consent, well, in fact, both consents are valid until February 2029. Mr. Tyler has acknowledged that he thinks 100 will be deliverable in 5 years. Yes, the outline is still valid until that date, but it's really down to the developers how quickly they want to progress things, and that's not a matter that the council controls.
Any more comments on row 40? Thank you.
I'll just say, so if I can add, in the forecasting, we have been mindful of the average timeframes, but there are a number of examples where Lichfields have referred to a range of, say, 3 to 4.6 or 4.8 years. Now, obviously, with respect to the appellant and the job they want to do, they have looked to go to the upper end of the range every time. Now, clearly, if it was to be, if you start to find that completions are delivered towards the start of that period, then it does open the door to a greater level of completions taking place. So we don't necessarily think that we're being unrealistic in what we're saying here.
So that's not entirely accurate. In fact, inaccurate. We've used the average as set out in figure 3.2. The range that Mr. Davey refers to is a range of averages across all sizes of site, and you will see from figure 3.2 that it takes much longer to implement smaller sites. When I say smaller sites, 100 to 500 homes, than it does, for example, for sites of 500 to 999. So we've used the size-specific averages. And I appreciate that they are averages, and therefore you might get dwellings slightly earlier or slightly later, but they provide a broadly credible threshold for considering the prospect of deliveries.
Right, thank you. Just on the planning to delivery period in 3.1, it does refer to sites of 500 plus dwellings take 1.3 to 1.6 years to deliver the first dwelling. Sites of 50 to 99 take 2.3. Sites of 100 to 499 take 3.2. We don't dispute there are singular figures in certain parts of the text, but there are other examples where a range is given, and the appellant's comments do acknowledge 4.6. But you'll see references within the document to 3 to 4.6.
Thanks.
In fact, I can quote from page 9, as it would be under a section called Outline Permission to Completion First Dwelling. That's just the point I was referring to, where Lichfields conclude, we have updated our findings on the average time taken from gaining outline permission to the completion of the first dwelling on site, as shown in figure 3.2. This indicates that it takes on average around 3 to 4.6 years from the grant of outline planning permission to deliver the first dwelling. And that's really all the point I was making. It's not anything the council controls. It's entirely a matter of the developer's own priority, and that's what affects the build-out rates.
So just for clarity, what the council have done is reference you to a paragraph which refers to paragraph 3.2, which is, sorry, to figure 3.2, which is the figure I'm using.
Thank you. Excuse me. Right, row 41. Any comments?
So this is a site with outline planning permission for up to 80 dwellings. Reserve matters have been submitted and approved for 54 dwellings, which are agreed to be deliverable. There is no application for the approval of reserve matters across the remainder of the site, and as far as I can see it, there's no evidence to suggest that completions will be achieved across the remainder of the site within the 5-year period.
I do have a question on this one. Given that the approval of the outline application was after the base date, how do I take that into account in the council's view?
So the outline planning permission for 80 dwellings was granted in September 2024.
Sorry, I misread that. That was you have said reserved matters. My mistake. Sorry.
Yeah, the reserve matters was approved in May 2026, and that was for 54 dwellings. So the 80 was the figure as of the 1st of April.
Yep.
Can I jump in on a complete aside?
Sure.
Just looking at the document that we've got in front of us, the paragraph 3, or the figure 3.2, just looking at the text that's slightly down to the left of it in relation to outline permissions completion of the first dwelling. Reading those two paragraphs, I would infer that Lichfield consider that their researches would go to the matter of meeting the MPPF's bar. Because obviously they talk about the clear evidence required to demonstrate the real slights, how it's accepted point is nothing new, and then goes on to say that they've updated it on that. So I would indicate that they consider that historical evidence of build out rates in sites generally provide some evidence. I think, we keep talking about clearance, but we also, it's clear and it's accepted. Sites don't even have to have planning permission sometimes be classed as deliverable. So I think it's, we're going to sit here and literally say every outline permission can't go in, but the position that you, in theory, could not make planning judgment and to say that every single outline site is not going to have one house built just feels a little bit farcical for me in principle.
I understand that, but obviously,
I get that. I'm just saying. I'm just reading what it means when we're talking about evidence deliverably. We're talking about this document, and this document is implying it is evidence that sites outline will be deliverable.
Yep.
The document that they're referring implies that. So I don't think we can pick and choose what parts of the document we want or don't want. If this is evidence of build-out rates, they are saying that this has been done to take into account the MPPF's requirement.
Thank you.
So I think Mr. Lee is drawing an inference that isn't there. So what the document actually says is it outlines the definition of a deliverable site, including the requirement for clear evidence, and then goes on to say, we have updated our findings on the average time taken from granting outline planning permission to the completion of the first dwelling on a site. So what this document is doing is seeking to provide a gauge of the realistic prospect. It's not dealing with the clear evidence point.
Sorry, I didn't come on the microphone there. Thank you very much, is what I said, which is let's move on to 42. Okay. Any comments on this one?
So this is a site which has recently gained outline planning permission for 425 homes. So once again, applying start to finish report, it wouldn't be expected that the first completions would be achieved until late 2030, 31. This site is, however, in control of the appellants, and they think that it will deliver slightly earlier, and therefore it will probably achieve 50 completions within the 5-year period. And that's what I've reflected. The clear evidence from the appellants is that this site should be relied upon as providing 50 rather than 100 dwellings as contended for by the council. And there's certainly no clear evidence that 100 completions will be achieved.
Thank you. This was the question that I had on the previous one that managed to muck up, but I'm going to ask it on this one. So the outline was given after the base date, and I was just wondering how that reflects in terms of deliverability.
So
we're looking at base date position.
Thank you, sir. So that had been under consideration for the best part of 3 years, and the decision was expected before that date. Yes, the date is listed as May 13th. In terms of the rates, again, the council doesn't build out the homes, we have, in this instance, we have to respect that BDW control the site. We're forecasting. We've referred back to Litchfields and their timeframes. So that's really all on that one. But they do acknowledge 50, quite considerably down to their own priorities. It could be more, but we can't say that for certain at this point in time.
So if I can assist on the post date, the base date point, this was an allocation at the base date, and so I think that's probably the answer that you needed on your question. So it can form part of the deliverable supply.
Yes.
Can we just close down this point? Given what Mr. Davies has said, it's the council accepting we can rely upon the appellants who are the controlling interest. They say it's optimistic, but we can put in for 50, but not the 100.
Any additional? Oh, sorry.
There was a nod, so I'm going to knock off 50 here.
So 43. Last one.
42.
Oh,
Still on 42. I got a nod, but I didn't get an answer.
Would you like to ask it again, Mr.
Yes, so well, again, through you, obviously. I heard what Mr. Davies said, that they have to accept the BW position. It's recorded as being optimistic to have 50, but we'll put it in for 50, i.e. not 100. And that can't be gainsaid. So are we agreed then we knock 50 off this particular entry? And I got a nod at that point.
Well, at this time, yes, you have control of the site. If your forecast is 50, that's yeah. I suppose we have to accept that then.
Thank you very much.
So that's agreed then. Thank you.
If we could just add this, the point about the start to finish timeframes is repeated, and you will see very clearly the circa 4.8 years from the grant of outline consent, as we referred to earlier. Litchfield do actually speak about a range, and that was what informed the forecast of 100.
Yeah, thank you. But that is it. Do we have an agreed position? Does that change that?
Yeah, we have to discount 50.
Thanks very much. Good. Site 40, row 43. Thank you. Any comments?
So this site has outline planning permission for 249 dwellings granted in October 2025. No applications to discharge conditions, no applications for the approval of reserved matters, and no evidence whatsoever that I can see to suggest that completions will be achieved. Furthermore, sir, based on the average lead-in times identified in the start to finish report, it would be unrealistic to suggest that 100 homes could be achieved in the 5-year period in any event. But the primary point, sir, is that there's once again no clear evidence that completions will be achieved as required by the framework and the consistent position of the Secretary of State and other inspectors.
Okay, thank you. Similar to the other sites. Anything from the council?
Again, it is a consent that was granted less than a year ago. So the outline remains valid until October 2028. It's clearly appropriate for it to form part of the supply as of the base date. The reserve matters can still be submitted at any time until October 2028.
Thank you. Site 44, any comments?
So this is a site has outline planning permission for 20 dwellings, granted just before the base date in March 2026. No applications for the discharge of conditions or for reserved matters, or again, no evidence whatsoever to demonstrate that completions will be achieved as required by the framework, sir.
Any comments from the council?
Yeah, I think it sort of speaks for itself really there, because the outline was granted just 5 months ago. So we think it would be incredibly premature to discount a site of that size at this early in the permission's lifespan.
Thank you. Okay, a couple of sites here which have been subject to applications which have issues, reserved matters applications. Row 45, any comments?
So I can probably assist with this one. Since I checked this site yesterday, the applicant has now submitted a drainage strategy to seek to overcome the objection, and therefore I'm happy to agree this site is deliverable for 9 dwellings.
Thank you. Row 46, any comments?
Thank you. So this one has outline planning permission for up to 149 dwellings, submitted in July 2022. A reserve matters application for 121 dwellings was submitted in May 25. In broadly September, there or thereabouts, it was subject to substantive objections from the lead local flood authority, the internal drainage board, and the Environment Agency in respect of deficiencies in the flood risk assessment. Since that time, the applicant haven't provided any response to those objections. In fact, there's been no record on the planning portal since October 2025. So progress on the site just appears to have stalled, and there remain substantive objections which need to be overcome in order to achieve completions. Now, as far as I can see it, there's no evidence to demonstrate that those objections will be overcome, or indeed that completions will be achieved, sir.
So we have had an update on that from the applicant, and they are currently working on minor amendments as requested by Highways. They're looking to submit these to the council next week. The agent's intention is that the developer will be looking to start work as soon after the consent comes through.
So if I can ask you, has the applicant indicated that they're going to address the substantive objection? Because there's no substantive objection on Highways. There is in terms of flood risk.
That's the comment they provided to us. So they're still working on it. Yeah, I understand your point exactly. But that we would consider would indicate that they do intend to progress the scheme. As we said in the comments, that the discussions were ongoing. We consider there was always intent to progress. The application is likely to be decisions likely to be taken autumn winter this year.
Sorry, so, autumn this year coming. Sorry, decisions likely to be taken. Sorry, sir.
In the as in the SOCG, autumn to winter this year.
Sorry, sir.
Sorry, that decision related to
SOCG.
Statement on the ground.
Sorry. Right, sorry.
Okay, thank you. Moving on to the strategic allocations, site 47, any comments? Or any comments on strategic allocations as a whole that can be taken account of all rows?
There are about 3 different categories these fall into, so it's probably worth working through site by site, and I will just say the circumstances are similar on this site as it was on the other side. So the first one, the LPA resolved to grant full planning permission for 294 dwellings in August 2025, subject to the agreement of a Section 106. In the subsequent year, no Section 106 has been agreed. We don't know what remains to be resolved, how long that's going to take to be resolved, or whether it will be able to resolve it. One of my other guys is advising on educational needs, and it's not uncommon that it takes 5 years just to agree a Section 106 itself. So there's and appears to be this obstacle. We don't know quite what it is or how long it will take to resolve. But even if that could be resolved, once again, there's absolutely no evidence to demonstrate that completions will be achieved within the 5-year period on this site, sir.
Yeah, we have actually had a recent update since our meeting from the developer on that. Now, the committee has resolved to grant consent for East West Beach. The S106 negotiations are a bit protracted. They're seeking changes to the highways triggers, and that's delaying the resolution. So this was a site allocation. The resolution to grant is there, which they recognise. They are expecting to start on site in 12 months. They are proposing a build-out rate of 50 to 60 dwellings per year.
I'm just wondering about because obviously I want to have a standard approach on all sites based on the base date of 1st of April. The information that has been received from both sides seeking updates. What weight do I give that? What weight would you consider is relevant based on that? Because as I mentioned, I don't want to take some post 1st of April information into account on some and not on others.
So if I can assist with that. The Secretary of State has set out in paragraph 12 of the Woburn Sons appeal decision, which you have at, let me see if I can find it, CD 13, I've mistyped, CD 13.19, that one can take account of evidence which postdates the base date to consider the deliverability of sites which were identified at the base date. So the Secretary of State is clear that you can and perhaps should take account of updated evidence. The issue we have on this site is that evidence hasn't been provided to the inquiry. From what I understand, there are, well, what Mr. Davey has said, there are issues which remain to be resolved. Clearly, nobody knows how long those will take to be resolved with Section 106. Secondly, from Mr. Davey said that the developers intend to start on site in 12 months. That is clearly contingent on whether the Section 106 matters are resolved. And then we don't know how long it will take until the first completion is achieved. You know, they'll have to do all the preparatory works, the landscaping, the internal road layout, the lighting, the sewerage, the utilities. So again, there's no clear evidence as to when actually completions will be achieved. And everything that Mr. Davey has said, we don't actually have the evidence of that. And the PPG requires that the evidence is made available, 68007 again, sir. And that's what the council hasn't done. But if the council is able to provide the written correspondence from the developer which supports this, that would be helpful.
Sorry for you, Chairman. So I'm on autopilot sitting in here. Weirdly, actually, I didn't realise it was this one, but I've actually had want of a better term, a complaint letter about this that I actually replied to last week from the developer. The issue with this one actually isn't the Section 106. They want to change the triggers in relation to the highways condition 35. We're providing evidence in relation to, we're in negotiations with that, with highways, we provide them with the information. So that is moving forward. It isn't actually Section 106 doesn't appear to be a problem with that. It's just the committee that went, resolution that went, my understanding from our complaint response is that case officer doesn't think it'll be an issue. It's just, it's taken a little while and should be coming to resolution. And, you know, in the complaint response, the applicant's quite clear they want, in the initial complaint, the applicant's quite clear they're looking to progress as a priority. But yeah, we can provide that if you want. So I didn't realise it was this site until, I didn't put two and two together until this conversation, sorry.
Again, so there's still an issue which needs to be resolved. And I'm surprised to hear that there's no issue with the Section 106, because the Section 106 still hasn't, in fact, the council identify in the Scott schedule that further discussions are, they're awaiting an update on further discussions. The Section 106 hasn't been agreed. There's not a draft of it available. So it appears, at least, that there are issues to be resolved with respect to the Section 106.
Can I just ask, through you, does Mr. Lee expect, therefore, the condition to be amended, in inverted commas, through a Section 73 application?
Is that the case?
No, it's through the wording, because the decision notice hasn't been issued yet.
Oh, I see.
So yeah,
Because
conditions were delegated to officers, and there's with some suggested ones, and they want a slight trigger change on one in relation to it. So we provided the evidence just for the sake of the time, I think my understanding was them giving us some evidence we're now providing to county.
The triggers came from the committee, is that right?
Okay, sorry. Mr. Ball's question was that the triggers came from the committee.
Through Chairman, no, they're delegated to conditions are delegated. We provide a schedule of suggested conditions and delegate them to officers.
Does the fact that the permission hasn't been updated change your change anything that I need to take into account then?
I don't think it does now. I think we think it's likely to progress in a timely manner.
Okay. Thank you. Right, row 48. Any comments?
So this is an allocated site which isn't even subject to a planning application, sir. Again, there's no evidence whatsoever to suggest that completions will be achieved, and it would be wholly unrealistic to suggest that completions would be achieved in the absence of a planning application on a site of this size. For example, turning to start to finish report, depending upon the size of this site, on average, if we look at figure 3.2, the size of the planning application, you're talking kind of 4.9 to 6 years from the submission of an application until the first completion. And I've also, in my proof of evidence, done an analysis of the lead-in times experience in Fenland, which suggests that depending on whether a full or an outline planning permission is submitted, it takes somewhere between 6 and 7+ years from the submission of such an application. So it's just not, it's wholly unrealistic to suggest this site could achieve completions, and there's no clear evidence whatsoever, sir.
Thank you. Could I ask the council to demonstrate its evidence there?
So, yeah, this allocation is partially covered by the land south of Barker's Lane and Winton Road, which has that outline consent in place. That covers 425. Now,
is Wimplington Road a separate site to what we're looking at here?
So yes, it's within the allocation. The Wimbledon Road one is 425 dwellings, and that is the allocation that was referred to a few minutes ago. There is a reserved matters pre-application inquiry at the moment to cover some of the remainder of the site. It is actually I believe it is actually BBW
Yep.
site.
Me too. Sorry, but there's reserve matters application. Does that relate to this particular site for 50 dwellings?
It relates to this strategic allocation.
Oh, strategic allocation.
Yes.
But in terms of this particular site, there's no outline planning permission.
At this time, no.
I understand that. Okay, so I understand that there are others. There are various planning permissions at various stages for others within the allocation.
That's correct. Yes,
Okay.
yes.
How does that relate to this site, please?
Yes. So the 425 at Barker's Lane, Winwington Road, that's one of those permissions for this allocation. There is another inquiry that's ongoing to cover the remainder. That's all. But I do understand that is one of BDW's sites. From the update I've got, but I will need the appellant to confirm if that's the case or not.
Okay, then. Thanks. Does that constitute the totality of the evidence on this one?
At the moment, because it's ongoing, yes.
Okay, row 49, please. Any comments?
So thank you, sir. This is subject to a full planning application for 152 dwellings, which the council refused in January 2026 and are actively contesting at appeal. So there are two outcomes to that appeal. Either the council that consider that the appeal should be allowed and therefore this site will achieve completions. But if that's the case, the council are clearly acting unreasonably at that appeal because they're defending an appeal which they consider should be allowed, or alternatively, they consider that appeal should be dismissed and therefore this site won't achieve completion. So a simple question to the council, sir, are they behaving unreasonably to other appeals, or is this site not deliverable? There's no middle ground, sir.
Yes.
Don't appreciate the inference, but I said it's an allocate site. Even if the appeal is dismissed, we think a subsequent application will come in, and clearly, it's an allocated site. It's not a principal issue. So yeah, I don't think there's only the two outcomes as implied, which I don't appreciate.
Yes, and I think it is important that witnesses don't take over the role of advocates. Man and a friend will make submissions, I'm sure, in due course. I think witnesses should stick to areas in their expertise.
So, in discussions with Mr. Davey, not recorded, Mr. Davey acknowledged that it wouldn't be realistic for another application to be submitted and completions to be achieved on this site. And indeed, that's exactly the case without an application, as with the preceding site. If the developer was minded to, if they lost the appeal and was minded to submit another planning application, that wouldn't realistically achieve completions within the 5-year period. So, in very simple terms, in order to consider this site deliverable, sir, you would need clear evidence that the council will lose the appeal, and then you would need clear evidence that completions will be achieved, neither of which you have. Indeed, the council contend the opposite, presumably, that they should win the appeal.
Just looking at that, in short, that's really not quite an accurate recording of the discussion. Now, we looked at this solely from a forecasting perspective. The developer has come back with an update and said that if the appeal is successful, they will be looking at a spring 2027 start. They also anticipate that the development will take 3 years to complete, so they confirmed to us they would expect that to complete by 2030. Now, if they were to lose, I think what I mentioned was, of course, there would be a need for an application to be submitted, but we do not control the timeframes of that. Now, if they were to lose, of course, we would have to go to zero. But from a forecasting perspective only, we've considered 50 would be a minimum for this site and the other schemes that were at appeal. That minimum threshold, therefore, is likely to be exceeded, and we've got confirmation from that based on the developer's forecasting.
Also, you've got to look at, the reason for refusals relate to information in relation to statement of drainage and potential impacts, lack of information in relation to on-site groundworks. It's, reasons for refusal for lack of information are slightly different to reasons for refusal due to technical objections. And on the assumption that the council wins the appeal, we're not saying that properties need to be rebuilt, redesigned, etc. This is, a matter where it potentially through, even if they probably are looking at some of this already and things. I think it's not one where you can say that this is a strong objection from the council to the delivery of the site. It relates to what the reason for refusal are. So there's a very big difference between an appeal being dismissed, which goes to the heart of the matter, that says this site should not be developed, the scheme you've brought forward is fundamentally flawed, and one where there is a need for additional information. Additional information is obviously a lot easier to bring forward and much more speedy than it is to bring forward a whole new scheme. That's what I just suggest.
So can we again be really clear here? The witness who speaks to this matter has just said to you that if the appellants were to lose their appeal, then the figure would have to go to zero. So everything you've heard from Mr. Lee, Mr. Davies has said it, I've written it down.
Come forward in 5 years if it was.
So everything you've heard from Mr. Lee shouldn't be taken to be in contradiction to the witness on this topic. So
round table, this isn't. Yeah.
The start proposition is Mr. Davey accepts if the appellants were to lose their appeal, the figure goes to zero. So he needs to give you clear evidence the appellants are not going to lose their appeal. No, you don't have that, obviously.
Thank you. What stage is the appeal at?
Final reps have been in. I think they've gone for final costs and final. Yeah, so everything. It's imminently a decision. Yeah.
And again, just to reiterate, we are looking at this quantum of 50 from a forecasting perspective only. At this time, we don't know which way the appeal will go. Obviously, if the council is to lose and the appellant wins in that instance, they've confirmed to us now that they'll be looking to spring start 2027, and they anticipate that they can build that scheme out in full within 3 years. So I think, given the NPPF definition of deliverable, it's perfectly realistic to include that scheme within the forecasting.
So there are 2 points that I'd briefly pick up. In order to be considered deliverable, the LPA must consider that the site is suitable now for the development being proposed. They clearly do not do so because they're resisting an appeal. Secondly, they need clear evidence that completions will be achieved, and that can only possibly be the case if they agree or consider that they should lose the appeal. I mean, this is just an unarguable site in my humble opinion. So
I think I've got what I need on this site. Thank you. Okay, row 50.
So this is exactly the same, only it's for an outline planning permission for 352 dwellings, which again the council has refused and are actively contesting an appeal on substantive grounds. So exactly the same applies. So the council can, on the one hand, say there's clear evidence that completions will be achieved, was resisting the application, which will be necessary to achieve those completions.
Thank you. Any comments from the council?
In regard to South Wiz Beach, there was an application refused at committee against the officer's recommendation. That's regarding culverting of the drain and surface runoff. So at the moment, we are still waiting an update from the developer on that, and what the likely timeframes will be in the event that that decision goes against the council.
For that one, there's a hearing on the 8th of September.
Thank you. As loath as I am to take any evidence into account submitted after the appeal closes, the inquiry closes, is there an appetite for me to take those into account, those decisions, if they're issued between now and when I issue the decision?
If they are, they will be material considerations,
yeah,
and it's up to you as to whether or not you choose to accept them.
Exactly. That's the thing. It's my decision. I was just seeking the views of
on the latter one, because the hearing's not due until September, a few weeks after this, it wouldn't be expected that that decision will come out before your decision. Obviously, it could happen, but it wouldn't be expected. On the written reps appeal, I mean that's possible that could come out at any time.
As much as I would like to say that I could issue a decision by the end of December, my schedule looks like a mad woman's breakfast at the moment, so it's I can't make any promises. Okay. Right. Any other comments on row 50? Okay. I'm going to go through until lunch break just on the remaining sites, and then we can talk about Windfall after lunch, if that's okay with everyone. Good. Row 51. Any comments?
So again, this is a site which isn't even subject to a planning application. No evidence whatsoever to demonstrate that completions will be achieved, and it wouldn't be realistic to suggest that completions could be achieved.
Right. So thank you. So the outline planning permission relates to part of this site.
No,
part of the there's an allocation.
Sorry, are we on the?
Oh, sorry, wrong name. Yes. Yes. Reserve that question for the next one. Any comments from the council?
Sorry, it's 51. 51, yes, sorry.
Issue?
Again, it doesn't have the current planning application in place, that is correct. We were simply looking at the fact that it's an allocation. It would be plausible for a small amount of delivery to come forward. Should an application be there? But it is an application. That's all really at this time.
So this is a site which the council resolved to grant outline planning permission in November 2024 for up to 1,000 homes, subject to the agreement of Section 106. That Section 106 hasn't been able to be agreed in the subsequent 2 years almost. And indeed, it was recently taken to Planning Committee to seek approval to amendments to some of the obligations which were before the committee when they resolved to grant planning permission. The committee, however, decided to defer making a decision and sought to go back to consultees to seek clarity on a number of issues, but also sought to move away from the Section 106 and seek a greater level, the draft Section 106, and seek a greater level of affordable housing in the first phase than had been recommended. So there are clearly demonstrable issues with the Section 106 which remain to be resolved. There's no evidence that those will be resolved. In fact, it's going to go back to committee in order for those to hopefully be resolved. And there's simply, once again, no evidence whatsoever to demonstrate that completions will be achieved.
Any comment from the council?
Yeah, so this site, there's an issue in relation, the officer's report explains there was funding agreed for off-site provision in relation to playing pitches, but that's no longer needed, so the appellant is now looking to provide them on site. And then there's an issue in relation to, it's agreed that phase 1 affordable housing will be lower and that will be made up in phase 2. The applicant has asked if that can now be made up in phase 2 and phase 3. Officers recommended approval. Members had a number of queries. Some of them do have some merit. There appears to be some lack of understanding because it's only part of the allocation in relation to public open space, in relation to pitches for the overall development. This is something that I don't think is a stumbling block. We may have to deal with it through an additional condition to abate the concern from members. The Section 106 generally has progressed quite a long way, apart from 1 or 2 challenges. The applicant's very keen to start on site, as in to get permission to move it forward with reserve matters. And so I don't see why 50 would be an unreasonable prospect. In relation to it going back to committee, potentially that's not the case because of change to national scheme delegation. Even it may be could end up in an interesting situation if there is no transitional arrangement where something like this, in theory, officers would suggest it's an allocated site broadly in line with policy requirements. Therefore, it would be wouldn't be able to go to committee.
Thank you. The 50 figure come from specifically.
So the figure of 50, I think just to explain the approach taken, given the previous schedule, which is referred to within the core documents from 2025 to 30, that allowed for a total of 578 from the allocations and broad locations for growth. Now, the figure has been reduced to take account of we're wanting to make it more robust for starters, that there has been progression on some of the schemes over the previous year, and also that the 50 is intended as a baseline on sites where there's a greater level of activity than others. So we don't think it's unreasonable. And again, in setting that, we were being mindful of the Lichfield's build-out rates as evidenced in CD 13.35.
Thank you. Could I ask the appellant, you've got any comments on the figure?
Well, yeah, there's no clear evidence that completions will be achieved, sir. So to include any is contrary to national policy. And we've also heard that there remain challenges to be resolved with Section 106. So
if I was to find that this one could
there
go
was
through.
clear evidence, the 50 could feasibly be achieved, possibly, but you would need clear evidence to include that 50. So.
Thank you. Row 53, any comments?
This is another one, so where the council had resolved to grant outline planning permission, but a section 106 has yet to be agreed. Now, given where we are with this site and applying the average of the start to finish, it wouldn't be expected that completions will be achieved in any event. So it's not realistic. There's no clear evidence to suggest completions will be achieved, and there are obstacles to be overcome with the section 106.
Any comments from the council, including how the 50 figure was reached?
Well, again, on this one, discussions are ongoing with the section 106. Mr. Tyler is correct; it's not been agreed as yet. The outline, the council resolved to grant the outline consent just 4 months ago. Activity is ongoing with regard to that site. So again, the 50 is just indicative of forecasting that should the consent be granted, everything be in place relatively quickly, it wouldn't be unrealistic to expect there'd be some delivery within 5 years. But again, this is subject to build-out rates, which we do accept are variable from developer.
Thank you. And any additional comments?
Not on that side, sir.
Okay. Right, lucky last 54. Any comments?
So this again, is a allocation which isn't even subject to a planning application. Again, there's no clear evidence to suggest that completions will be achieved, and it would be entirely unrealistic to propose that completions will be achieved given the start to finish and the record of the lead-in times which have been experienced in this LPA.
Any comments from the council?
The site is not currently the subject of an active plan application. That's correct.
Right. Thank you.
Thank you, sir.
I just, I've been running a total going through.
I was
if I give you
someone was going to get out
I
their
was thinking
calculator. It's the
I'm going
first.
to give you the figures now, so just so we can have them checked over lunch and make sure they agree between the parties. I recorded through, and the concessions went both ways. Mr. Tiley also gave some extra figures back into the pot. -3, -1, -60, -50, and +9 were the figures that I got.
Would you confirm the row numbers?
I'll try and do that.
I've updated mine and Mr. Davies' schedule, so we should be able to put this in and just as an agreed document. I think I've made a note where there's been concessions on either side.
Just to help yourself, mine is 10 is -3. Then you've got 24 is -1. 25 to 31 were a group that became -16. Then 39 was the -60. 42 was the -50. And trying to find the +9.
+9 was London's to 13B Bridge Street.
So what was that? What was that number?
Sorry?
What was the number?
No, it was the 13B Bridge Street, which is 45. So that's +5 on our position. Sorry, +9 on our position. And in aggro, it's -130 from the LPA's position.
Yeah. Okay. If those agreed positions can be checked over lunch, then we can come back.
Let's move on to the pit side as well.
No,
we're taking into account.
Oh, sorry, the 9 was already taken into account. Yeah, sorry, in my note, which was submitted yesterday. So those are already included. Sorry, the 9, yeah.
Could I have an updated Scott schedule, please? At some point before Thursday? Thursday
Do
morning?
you just want the?
Okay,
You
I
don't
want three
comments,
things.
or do you?
I'd like an updated Scott schedule. I'd like a summary of the changes in a short table, and I'd like an update to your table 1.1, please,
Table 1.1, right? Table 1.1, Scott schedule.
in your note, revised note.
Scott
That's
schedule.
B009.
summary changes.
Is that acceptable to everyone?
Yes, sir, thank you very much.
Thank you. Gosh, listen to me being more forceful. In that vein, it's time for lunch. Have a good lunch, everyone, and we'll be back at 14:10. Is that enough time to get to the CAF?
I think the CAF comes to us, actually.
Okay.
So I think that's how it
Right.
works. Thank you.
This is an unfolding story. Every lunchtime, there's more to it. It's
I
like
know,
EastEnders.
I know.
Okay, thanks very much, everyone. 14:10.
So
good attention grabber anyway. Thanks very much, everyone. We'll resume with windfall sites.
Before we get there, just to let you know, in the lunch break, Mr. Tiley has been able to do those 3 documents for you, and they've been pinged over to Mr. Davey, so hopefully you'll get them sooner rather than later.
Thank you very much. If I haven't said already as well, thank you for the extra evidence this week. I know it's quite an imposition and a fair bit of work, and I do appreciate it. Thank you. Right. This is the position, as I understand it, with windfall at the moment. So the inclusion of windfall provisions been mentioned with regard to the new NPPF policy HO3, which is a plan-making policy and allows for, at the plan-making stage, the windfall sites as part of the identified supply. There's also Annex D, which only includes deliverable sites in the calculation of housing land supply. And there's the PPG, Housing and Economic Land Availability Assessment as well. Question to the appellant on the policy HO3, the plan making policy. I know that you that it may or may not be relevant depending on the views of the various parties. HO3 says that there should be compelling evidence that they will provide a reliable source of supply, and that any allowance should be realistic, having regard to the land availability assessment, historic windfall delivery rates, and expected future trends. Do you consider that the council's provided that in its evidence?
If a windfall allowance is allowed within the deliverable supply, then there's no dispute as to the council's allowance. The sole issue in dispute is whether or not, for decision-making purposes, one is allowed to include a windfall allowance. And if I spend some time taking you through the NPPFs, it might provide assistance. If we start with
before we bring the numbers, if you go to Mr. Mr. Tiley's note, table 1.1, that figure of 5.27 isn't in dispute if you're allowed to have windfalls in a 5-year land supply. So that I hope will cut through some of the concerns about the appendix, the soi-disant appendix 1, and the equivalent appendix in the note, because the principle of calculating 527 isn't in dispute, but we're not in a plan-making world, and so it's irrelevant to our purposes. That's why we say it comes out.
Of course, I understand.
So we can go through the NPPF to explain all of that.
Yes, thank you.
So if we start with paragraph 8 of the introduction, sir, which is on hard copy page 4, which I think is PDF page 6, it identifies the second sentence thereof. The plan-making policies should not be used when making decisions on development proposals. So the NPPF provides a clear direction that we're only concerned with decision-making policies for determining this planning appeal. If we next turn to policy S5, sir, which is a decision-making policy.
Sorry, I'm running a little bit slow here. Just bear with me.
And S5, when you get to it, sir, is on PDF page 27.
No, I'm still dealing with the first point. Sorry, so that's paragraph 8 first.
Yeah, paragraph 8.
Sorry, there's a bit of scrolling to do there.
One shouldn't apply plan-making policies, so we're only concerned with decision-making policies, bearing in mind we're concerned with decision-taking here, sir.
Thank you.
We turn to policy S5, which is a decision-making policy, sir, and S5J, sir, which is the one that brings in the 5-year land supply. It's on PDF page 28, actually, the part J of that policy.
Thank you.
Part J says development which would address an evidence unmet need, including but not limited to development proposals involving the provision of housing where the local planning authority cannot demonstrate a 5-year land supply or scores below 75% in the HCT. And then it's got a footnote 27, which directs you to Annex D for those purposes. So the decision-making policy relies upon the 5-year land supply calculated in accordance with Annex D. So if we turn to Annex D, sir, which might be easier to find than you might find easier, is PDF page 120. Yeah. And we're concerned with the 5-year land supply here, sir, which is set out at the bottom of page 118, PDF page 120. So for decision-making purposes, sir, it says local planning authorities should identify and update annually a supply of specific deliverable sites. Windfall sites aren't specific sites, sir. So the NPPF is clear that one cannot include a windfall allowance in the deliverable supply for the purposes of decision taking. And then, sir, if we turn to the PPG on housing supply and delivery, sir.
Yep.
And we've been there before, sir, but 68-007, what constitutes a deliverable housing site in the context of plan making and decision taking?
Sorry, this is housing supply and delivery.
Yeah.
Paragraph
68-007.
Thank you.
And you will see there, sir, at the start of this section, it identifies that at the end of that first paragraph, as well as sites which are considered to be deliverable in principle, i.e. those in category A, this definition also sets out sites which would require further evidence to be considered deliverable, and then identifies the category B sites. It makes no provision and actively precludes the inclusion of a windfall allowance. And in fact, sir, if you look through the entirety of this section of the PPG, which is the section of the PPG which deals with the deliverable supply, it makes no reference whatsoever to a windfall allowance. And that would be not only is it clear from national policy and guidance that you can't make an allowance for windfall in the deliverable supply, it would be very strange to suggest that the section of the PPG which deals with this makes no reference at all to windfall allowance. You did draw attention to plan making, and as we've set out, the framework is clear that plan making policies don't apply for decision making. But if we turn to the plan making policies of the framework, sir, and HO3, as you see, part 2 of that policy sets out that an allowance for windfall can be made. But if you scroll up a few pages, it identifies that that is a plan-making policy. Yes. Which the framework tells us cannot be used for decision-making purposes in paragraph 8. Yeah, and in fact, within HO3, part 1, let me turn back to it, sir. It sets that local plans should identify, so again, it confirms it's a plan-making policy, a sufficient supply and mix of sites to meet or exceed the housing requirement figure and pitch and plot requirements for their areas over the plan period, drawing upon the HELA, etc., etc. Then it goes on to say, in relation to housing, this should include a supply of specific deliverable sites for years 1 to 5, which is the period we're dealing with deliverable supply in years 1 to 5. And then it says a supply of specific developable sites or broad locations for growth for subsequent years. And windfall is a broad location for growth. So even for plan-making purposes, the NPPF is clear that windfall allowances can only be applied for years 6 onwards. And again, that's confirmed by the guidance, sir. If you turn to the HELA part of the PPG.
Sorry, the
Housing and Economic Land Availability Assessment part of the PPG.
Good, I've got it up already.
And section 3-023.
Got it, thank you.
It says, how should a windfall allowance be determined in relation to housing? And it says, a windfall allowance may be justified in the anticipated supply if a local planning authority has compelling evidence. Then it goes on to say local planning authorities have the ability to identify broad locations in years 6 to 15, which could include a windfall allowance. So the guidance is yet again clear that the windfall allowance provides a broad location, which can only be included in years 6 to 15, even for plan making purposes, sir. So national policy is crystal clear, sir, that the inclusion of a windfall allowance is precluded for decision-making purposes, and even for plan-making purposes, it can only be relied upon for years 6 to 10, which are irrelevant for decision-making purposes, sir.
Right. The first bit of that paragraph states that windfall allowance may be justified if anticipated supply has compelling evidence, as set out in paragraph 70 of the previous MPPF. I was going to check what that related to. Do you know off the top of your head?
That was the same as in
Same as this one.
within HO3.
Okay, thank you.
Or broadly speaking, but this is a part of the PPG which relates to plan making. It's a HELA, which is a plan making informing document.
Yes.
And it's saying if you've got compelling evidence, you can identify a windfall allowance. It forms part of the broad locations, which you can include for years 6 and beyond.
Good, thank you. That was my first question on that section. My second is, do you think that the PPG's weight, the PPG's applicability is changed by the new NPPF at all?
Well, if there was any conflict between the two, the NPPF is the more recently adopted expression of national policy, and therefore the NPPF, which is crystal clear that you can include a windfall allowance, would be afforded greater weight. But as it so happens, the PPG aligns wholly with the NPPF and precludes the inclusion of a windfall allowance.
Right. Thank you. Could I ask the council to respond, please? Have you got a list of all those points?
Okay, I think we understand the position. I think in the first instance there may be a clarification needed. At the very top, it was said that 527 is no longer in dispute if we're allowed to have it in the new NPPF. Have you said that, Mr. Tiley? And that is your position now.
Yes, sir. If a windfall allowance is permissible, then 527. We've no dispute with that figure.
Okay.
But the issue is solely whether that number is permissible, whether such an allowance
so
is
we've
permissible.
established there's no dispute then, sir. I would point out that was the whole reason for the disputed schedule being published. That is solely, it was evidence to the inquiry as a list of permissions that have been granted post 1st of April only, and not an attempt at all to change the base date. And you will have noticed that paragraph 18 onwards of Mr. Tiley's NPPF note did in fact refer to an attempt to change the base date, which it is not. He also did some very helpful analysis of the list, which we haven't done. There's no need to rebut it, which concluded that there was 154 homes that are additional. 107 of those are category A, and therefore they are not part of the council's calculations at this time. So that really just affirms our position on windfall all along, because we took account of paragraph 75 of the old NPPF as it was, which was quite clear that where there was evidence of historic supply and likely future delivery, we could take account of that, so it was factored in. The windfall allowance within the calculation is 211. So the fact then that we've had 154 homes granted consent in the first 4 months of the financial year really just confirms the point.
Okay.
It's a yes or no position, and they can't argue both simultaneously.
Right. Okay. Do you have anything directly in response to what Mr. Tiley said just now with regard to the procedure that he took me through?
So yeah, I think I might pick that up if that's okay. Don't think anyone's going to disagree that the new NPPF is quite clear that there were decision making and there were plan making policies. I think that's quite logical. I think it's quite clear. I think that's quite helpful. I think though, when we go to policy HO3, obviously is the one in relation to plan making. It obviously uses the term specific deliverable sites at A and 1 and 2. And obviously then goes on in paragraph 2 to explain that windfall sites can be used. I would suggest that accepts that a windfall site can fall under the definition of a specific deliverable site. There is, obviously that is the exact same terminology used in the 5-year land supply point on Annex B of the MPPF. D, sorry. Sorry, people decided to start emailing me consistently. The exact wrong side. So I think that's a key point, is that actually the terminology is consistent. I don't think there is a need for the document to repeat itself continuously. I think an argument that if you're able to put windfall sites into your housing allocations, an argument that you can then not use them in producing a 5-year land supply is quite counterproductive. Particularly certain authorities that nearly all, they don't allocate sites, they rely on windfall developments, sites coming forward that have already been brownfield, etc., quite urban ones. One of those authorities would never be able to demonstrate a 5-year land supply. Because if they weren't able to put in windfall, and on the argument that outlines, etc., we've had here, those councils would constantly have a failure to deliver it. And that's not what the planning system is set up. The guidance is not set up to make people fail. It's to be taken in a balanced, fair, and appropriate reading of it.
I've certainly come across councils in the past where windfall has been included in 5-year housing land supply, which is obviously under the old NPPF. And in your view, does the new NPPF change any part of the either the procedure to identify and include windfall sites, or the applicability of the PPG?
I personally don't think it does. It does. If the government did not want you to be able to have windfall site within the 5-year land supply, they would have said that. They would have explicitly said that 5-year land supply is not an appropriate way of calculating your 5-year land supply. You can't take into account historic provision. As you said, other councils, it's their predominant deliverer of their 5-year land supply. I know that was under the old system, but we can't be in a situation where the government expects all these councils suddenly to have, very small 5-year land supplies, especially if they are able to demonstrate, they're meeting the housing demands. Those things go hand in hand.
Okay, I've got to make rather a long note here, so if you just bear with me. No, it's very, very helpful. I'm just trying to summarise for myself because it's quite an important point. Has obviously implications for other appeals and decision making as well. So just bear with me for a moment. Thank you. I think we might have covered that. Is there anything else?
One point that I'd like to raise before Mr. Ball comes in. If we turn to Annex D and paragraph 8 thereof, sir. PDF page 120, I think.
Yep, got it.
It says local planning authorities should identify and update annually a supply of specific deliverable sites. I think we're agreed that that this council cannot identify a supply of specific deliverable supply sites as required by this part of the framework. The council's suggestion is that if you're allowed to include an allowance of non-specific sites, then they think they can. I'd still be of the view that they couldn't, but that's their position. But just reading the policy as it's written, I think we're in agreement that the council can't demonstrate a supply of specific deliverable sites.
Mhm. Do you have anything to respond to on the council's view just now about the positivity of the planning system and the fact that the government wants to help sites come along and therefore not to have a 5-year housing land supply because this position would affect a lot of other councils as well, would be counterproductive?
No, it'd be exactly the opposite, sir, because what it does is makes it harder to demonstrate a 5-year land supply, and therefore the presumption will be engaged more commonly, and therefore sites will be allowed more commonly. It will promote the government's agenda to significantly boost the supply of housing, sir. It's exactly the opposite of what the council suggested, sir.
Very small point on that, if you don't mind, but obviously I don't want to, because it starts getting more into probably what I'll be talking about, whether I like to or not, in an hour or so. Obviously, the new policies in relation to S4 and S5, the presumption is triggered on S4 permanently. The government's very clear that that's where housing should be provided. And then there is a much stronger resistance to development outside certain boundaries than previously. So actually, I don't agree at all with that point that the government almost wants everybody to not have a 5-year land supply, because it would mean it was triggered. Because if that's really what they wanted, they could just put the presumption in favour of sustainable development right through rather than having a threshold. So I don't agree with that point. I think that's something just don't think we need to be discussing my budget. I just don't agree with that. Thanks.
Yeah, no problem. That's something to pick up in planning, definitely. Unless you have a response
Just to say, I think Mr. Lee's reading a different framework to me to suggest that it's meant to be more restrictive on housing outside of settlement boundaries. The whole objective of the NPPF, as trailed through numerous written statements, was to promote the supply of housing, deliver more. The tilt has gone even further, because now the adverse impacts need to substantially outweigh rather than significantly. So I fundamentally disagree with the premise of Mr. Lee's suggestions.
So I can just make 2 points in reply. I mean, obviously, this is not a planning witness. We'll deal with planning in due course. You'll hear to talk about 5-year supply. The second point about the NPPF, this point Mr. Lee has made, as you've rightly said, sir, lots of councils up and down the country have, under the old NPPF and PPG, relied on windfalls. And I think it is a fair assumption, and it is a fair position, Mr. Lee, to say that it's the government who should be taken to understand the way in which the planning system operates, is going to propagate a new position. They're not going to do this opaquely and sort of sneak it in, as it were, without expressly making it clear in, for example, the consultation material that, for example, the government has been aware of a tendency to include windfall sites, no longer considers that to be appropriate, and therefore henceforth should not be the position. The government has not made that clear expressly. I think if that was the government's intention to change what had been a very important part of 5-year supply for a lot of local authorities, it should be taken to have done that. It would have done so in an express way, and the witness, you acknowledging your own proof that under the previous system prior to the draft NPPF, you said windfall allowances were included even in your own calculations. The PPG, for instance, which you referred to, is dated 2019. For example, so I don't think you would have to be able to point to something positive in the new NPPF, in my view, to suggest that the position is that you can no longer rely on windfall sites as part of your 5-year allocation.
So just to pick up on Miss Brian O'Reilly's representation, which was an unfair characterisation of my proof. What my proof says is I have previously included windfall allowances, but in light of the draft NPPF, I reviewed previous national policy, as it now is, as in the 2024 framework, and that didn't support a windfall allowance when read alongside the PPG. So this isn't a new position, sir. This has been the position of national policy since 2018, 2019, something like that.
Is there any change at all with the new NPPF then, from what you can see?
Well, it's clearer now. It's that much clearer, which is why I've picked up that actually it was exactly consistent with the former NPPF. It's now, to my mind, absolutely crystal clear. There can be no argument that it provides for a windfall allowance for decision-making purposes. It couldn't be clearer, sir.
Okay, thank you. Do you think the NPPF is more difficult for councils now, including windfall overall?
I'll let Mr. Lee pick up on that point in a moment, sir, but I'd refer you to CD 13.33. 13.33, which is the Mead Realisations Judgment, and paragraph 41 of that. And I'll just read from that. Holgate J understood the interdependence between NPPF policy and PPG guidance when he said, in paragraph 70 of his judgment, that as a matter of policy, PPG is intended to support the NPPF, and therefore it is to be expected that the interpretation and application of PPG will be compatible with the NPPF. I agree. Given the function of guidance in the PPG to support policies in the NPPF, one would not expect the government to publish policies and guidance that are inconsistent with each other. This would not only be counterintuitive, it would cause needless confusion about the government's objectives.
I missed the initial reference. Sorry, Mr. Day.
So it's paragraph 41 of core document 13.33.
Core document. Sorry,
And clearly, if
can you just bear with me?
If something within the PPG was inconsistent.
Sorry, just bear with me while I open the document. I just want to make sure I've got a full understanding of that before we go on. Did everyone else get the reference? Okay. It was core document 13.3, paragraph 41.
So it's 13.33?
Sorry?
13.33.
13.33, core document 13.33, paragraph.
And it's the
14.
Court of Appeal judgment, Mead Realisations Limited, and Secretary, SLS, and annual 30th January 2025. And I refer to paragraph 41 of that.
Yes. Understood, thank you. Sorry, you were going to make another point or extend that.
Oh, you've made your point too. Yeah, if you had a question, sorry. I suppose the other side is going to say, of course I'm going to say this, but I don't think it does any changes to the NPPF. Don't make it any harder for councils to include windfall. I think acknowledge that it is a housing policy HO3, but it uses the same terminology as 5-year land supply. It acknowledges that windfall sites can be those. I don't think, from my reading of previous guidance, etc., the government likes to repeat itself. You only have to go back to, was it when they introduced TPS 25 all those years ago, they didn't explain how to do a sequential test because it was already in the retail one. The government doesn't repeat for the sake of it. There's no benefit in that. It's clear there. Obviously, I don't agree that it's crystal clear, as Mr. Tidy was saying, and that's my honest professional opinion. I think none of this changes the case law that says you can rely on them. And obviously, I know a certain appeal decision will have less weight now because this is a material consideration has changed, but case law appeal decisions have evidenced this, and I echo what I said earlier. It was that if they were going to change this, they would have made it a bit more obvious rather than trying to subtly bring it in without any cleared up clarification.
Mr. Tiley has 3 points, and then I'd like to make a comment, please.
Yes, thank you, Mr. Tiley.
Thank you, sir. Mr. Lee repeatedly relies upon the same terminology being relied upon in HO3 Part A, Part 1. Sorry, 1A1. But if we actually turn to that policy, sir, which is on PDF page 34 or 35 of the framework, I think.
Thank you.
It sets out that in relation to housing, a council must identify a supply of specific deliverable sites, i.e. excluding non-specific windfall allowance, from the attended date of adoption of the plan with an appropriate buffer as set out in Annex D. Annex D again requires specific deliverable sites, i.e. excluding windfall allowance. So it is using the same terminology, and it's saying for years 1 to 5, as I've discussed and as accords with the guidance, you don't make a windfall allowance for plan-making purposes, let alone for decision-making purposes. So the same terminology is used throughout to provide clarity that windfall allowances are precluded from the deliverable supply for plan-making and decision-making purposes. So they are, for plan-making purposes, they're allowed as part of the developable supply, but not the deliverable supply.
Can you point me to a reference that specifically precludes any sort of windfall consideration?
Yep, sorry, well, firstly, Annex D, it requires a supply of specific deliverable sites. Windfall allowances are not specific deliverable sites. You would be in breach of national policy if you were to make an allowance for non-specific sites within the deliverable supply. Okay. It's as simple as that, sir.
Okay.
And Mr. Boyle, oh, sorry, I had 3 points.
2 more points.
Yeah, Mr. Lee also made reference to case law. All the case law that the council provided addresses different policies in different versions of the framework, or indeed the PPTS, the planning policy for traveller sites. So it's of no relevance because case law addresses the policy for it. And then Mr. Lee again said, if this was a change, you'd expect it to be publicised. And as I've said, it's not a change, sir. It's exactly consistent with the former MPPF in my view, although that much clearer.
Thank you.
And Mr. Boyle?
Just a moment, Mr. Boyle. Thank you. Yes. Sorry, I said thank you. And,
I wasn't looking at you, I was looking at the document. Actually, to be fair, Mr. Tiley in his first point covered what I was about to say, which is if you recognise the word specific in both little 1, little 2, that cannot be an allowance windfalls because windfall allowances by definition are not specific. And that actually is consistent with the PPG you were taken to. So there's no need to worry about mead realisations and Mr. Justice Holgate, because that also, the paragraph you were taken to, reminds everybody that windfall allowances are in the broad locations category rather than the specific site category. When we get into Annex D8, we are in the specific site category, and it's Annex D8, which the decision-making policy, which is S5J, is relating to.
Decision making, decision taking. No, yeah. Yes, we don't have plan making and decision taking in the new NPPF. I don't think so.
Plan making and national decision making.
Oh, good. I always got mixed up between taking and making. Okay, right.
So one observation on that last point, and that's just quite simple. Where is the benefit for the government and government policy to have an NPPF that's inconsistent or incompatible with the PPG? That's just the conclusion.
I don't know where this comes from. But there's no inconsistency. We're saying it's entirely consistent.
Yes, I've walked you through the PPG, and it is exactly consistent with the current framework.
Yes, you did. We've got two different views again.
The PPG aspects of it were drafted in the past. Yes, there are sections that still have to be updated to reflect the 2026 NPPF. We fully appreciate that. There may well be some further clarity on this point, but the land supply position is of relevance both for plan making and decision taking. So there may well be some changes to the PPG to clarify the point, because we've obviously noted that HO32 is only within the plan making. That's noted. It's accepted that you can't use plan making for decision making under the new NPPF either. So that's another point. But the consultation document for what was the draft 2025 NPPF was explicit under HO3 that paragraph 75 was included within that.
So if we can turn to that document, because what Mr. Davies just told you is incorrect. We have it at CD 13.57.
CD.
13.57.
13.57. Okay, just give me a moment, thanks. Okay.
And on
Opening.
PDF page 41, which is the government's explanation of policy HO3.
So this is last year's documents.
Yeah.
I really need to give them different coloured covers or something. 41.
May I read that, sir, just to help?
Sorry, Mr. Davey. I just want to find that reference and let Mr. Tiley finish his point, and then I'll pass it back. So 41. Yes.
So PDF page 41, you'll see HO3 is about halfway down the page, running on phones. And the explanation the government say is policy HO3 sets out requirements for local plans to identify a sufficient supply and mix of sites to meet the requirement figures set out in policy HO1. So this is a plan-making policy. The supporting document confirms that HO3 is a plan-making policy and should be only be used for plan-making. So it's of no relevance to decision taking.
If you go and look at the old NPPF, you'll find paragraph 75 indeed within the plan making section identifying land for homes, and the equivalent of paragraph 8 in Annex D is found in paragraph 79, which is maintaining supply and delivery. That's the identifying and update annually a supply of specific deliverable sites.
Annex D. Thank you, Mr. Tiley. Sorry. Thank you,
Mr. David.
Mr. Davey. I'm sorry. I really need a clearer identification system here. Sorry, Mr. Davey.
Yeah, that's fine. So
It's the second time that's happened. I do apologise.
Yeah, well, I think as we were saying, being pragmatic, we recognise the framework was only published last week. Sometimes with national policies, it has happened in the past where in 2018 the NPPF was revised. A few months later, there were updates in early 2019. It may well be that there are changes to this version. This is, I think we both sides of the table will probably agree, this is quite significant. It does seem to be an area where there is potential for some further clarity because this issue is relevant to both plan making and decision taking. Given the application, the presumption in favour, and how that works with regards to land supply.
Yep. Okay. Thank you. Yeah, you're right. It is significant. I'm going to flag it with our leadership because I'm not sure if anybody else has just yet. So there's going to be all sorts of implications, as I said.
We may be the guinea pigs. I think we recognise that with timing.
Yes. Yeah. Thank you. I want to wrap this up. Is there a final say from the appellant?
No, sir.
Okay. Right. Anything else on housing land supply then, before I close the roundtable session? Thank you for your contributions, everyone, and thank you for helping me as well with my reduced level of knowledge as to how I might have wanted it. Thank you. Mr. Davey, thank you for your contribution. Likewise, Mr. Tiley. Planning. Mr. Lee, would you like to get comfortable?
So it's one in terms of time, Mr. Lee is going to be back to
Right. Okay. Absolutely. Can we fit everything in tomorrow if we do planning tomorrow?
Yes. And I think that there's an advantage to that in that if we can get these tables agreed.
Yes. Sorry, I thought you meant the layout of the room.
No. Thank you, sir. No, the housing land supply tables, and then we'll be working off a firmer footing when we're asking some questions tomorrow.
Thank you. Good call from the council there. We all get a bonus afternoon. Well, in a matter of speaking, yes. Well, yes. A bonus afternoon in front of the computer on our own rather than with everyone else. Is there anything else that anybody wants to say today before we adjourn? Oh, absolutely. Logistics are important. That's
right. I'd hope to give you an update on conditions 106, but it's still relatively fluid, so
No problem, thank you.
we'll come back to that tomorrow.
I have one point for you, Mr. Boyle.
Yes.
Mineral safeguarding.
Yes.
The position of Mr. Derbyshire in the proof that I've read it is that there's no change. The council has mentioned, as Mr. Lee in his evidence has made reference to mineral safeguarding. Could I ask in your examination in chief that you bring that out a little of Mr. Derbyshire?
By all
I'm
means,
looking for
you've seen the technical report we have in his appendices.
Yes.
Yes.
Thank you. Specifically in relation to the new NPPF. Thanks very much. That's it from me for today. Thank you, everyone. We'll resume tomorrow at 10 o'clock. Happy to do it half an hour earlier if necessary. Great. Okay. Thank you, everyone. Inquiry is adjourned.